Welcome to another time capsule. So it's day 2 of what was announced originally to be a 4-hour hearing on mom's motion to reinstate visitation with her daughter. This one starts in true time capsule fashion with all the technical and practical issues, disorganization and confusion. And then finally, we get into some actual testimony. If you thought day 1 was wild, day 2 doesn't disappoint. First up is detailed testimony from the CASA volunteer. She talks about her observations and concerns throughout the case and has very strong opinions as to whether or not this child should be forced to once again visit with this mom. But mom's counselor would offer a different side of things. He says she's doing great and she's thriving and in recovery. Despite many of the things that we heard yesterday and will continue to hear today, he thinks she's sober, working her program, and doing wonderfully. But he was kind of blissfully unaware of a lot of things. But I guess it's his job to take his client at face value, so we can forgive him for that. The level of snark today has intensified from the first day. We're pretty close to a code red level right off the bat. I think a snark and shade content warning might just be necessary. I have a feeling everyone's going to be exhausted by the time this hearing's over. But without any further delay, let's just find out and get right back into it.
Okay, I'm nursing a sinus attack, and I may have my sound and monitor off, so you'll have to see me blowing my nose. Where did we leave off last week?
That's a really great question, Judge. Unfortunately, let me check to see my...
From my notes, I show that Dr. Miller was our last witness.
Okay.
Yes, I agree, Miss Sims.
Okay, and whose witness was he, or he was subpoenaed by multiple people?
I believe that was Miss Pearsall's witness, Judge.
So Ms. Pearsall, what other witnesses do we have today?
Judge, we have Jenna Furman and Tyra Moisier, and I may or may not have a rebuttal witness.
Okay, and were Ms. Furman and Moisier sworn in last week? I don't think Ms. Furman was.
Ms. Furman was not. I believe Ms. Moisier was.
All right, Ms. Furman, do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, I couldn't hear you.
I don't think she's connected to audio, Judge. Ms.
No,
Furman, if you go to the microphone section.
She's not muted. She had just unmuted herself.
But the audio is not connected to the system, Judge. If you go down to the
option to mute her
microphone,
right.
And
option to mute her if she's not connected to the audio. So there's a problem certainly, but it shows that she's connected because I don't get the mute option if the audio is not connected.
Okay.
Obviously, it's not working. All right, ma'am. What sort of microphone do you have? Do you know? 5 minutes. You want to send us a chat message?
she could try to log off and log back in.
That's unless she's got a better idea. Yes, I was going to say in chat. And we have no idea what you're saying. If you want to log off and come back, that's good.
She's got a...
I think she just locked up.
Yeah.
I just muted you and asked you to unmute. I don't think that'll make a difference, but say something, please. No difference. So please log off and come back on.
Jenna, you may need headphones.
She's going to try to log back in.
I know that she's currently at school. It's the last day of school. She was trying to get everything done, but she is working from the school right now. So I'll text her and see if she's having
here we
any
go.
issues.
No.
No difference.
Ms. Furman, can you maybe borrow someone else's computer and try to Zoom from there?
The other thing she could try to do is to call in on her phone and mute the screen, well, I guess it wouldn't matter since it's not picking anything up, but if she mutes her microphone and calls in, that might work. Seen that happen before.
You only have one set of speakers, yes. So mute everything and then call it on your phone.
Ms. Furman, do you know the number to call in?
I'm putting it in chat now. if you can copy the link, and I'll try to text it to you also, because that's the link for one-click dial-in.
Thank you, Ms. Simpson.
Teamwork makes the dream work.
Spoken like a true team mom.
And a Jennifer's phone or iPhone got to the waiting room a couple of minutes ago. I hit admit, but they went away.
Can you hear my voice now?
Yes, ma'am, but I need you to shut off the speakers on your computer because we're getting feedback.
Feedback. Okay, done. Maybe not.
Put yourself on mute.
I can't hear you now. I think you need the microphone and the speakers off on your computer, and you're just using the computer for visual.
Right. I'm trying to get, I've got 4 speakers to turn off.
There's still something out there.
You could just disconnect from audio.
So you should be able to hear me and see me. Can you hear me and see me with no feedback?
It's better.
Yes.
It's not very loud.
I had to get 4. I had to get 4 to shut off. Sorry.
Okay, you may need to hold the phone up closer to you because I can't really understand what you're saying.
Can you hear me now?
Barely, but yes.
All right, now?
Yes.
Oh, sweet.
Okay, so,
Thank you for your patience.
pardon me. All right. Do you solemnly swear or affirm that testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth? So help you.
Yes, I do. Yes, sir.
Okay.
Yes, sir.
All right. The rule has been invoked. So who is going to be the first witness you call?
Ms. Furman.
All right. So Ms. Mosier, I'm going to place you back in the breakout in the waiting room, and we'll admit you when it's ready for you to testify.
Your Honor, they are CASA. They were allowed to participate through the entire proceeding on day 1. They're just 2 volunteers.
Okay. I'm sorry. I thought that was.
They're both with CASA.
Okay. We had somebody in the waiting room last week who never got a chance to testify. I thought that was her, but no. Okay.
And I believe that was Miss House's witness.
Okay.
So, and Judge, if you see Lucinda De La Garza log on, she is that same witness, and she was in the breakout room. So she'll be logging on today.
Okay. All right. So anything we need to take up before Ms. Pearsall calls her first witness?
Yes, Judge, we filed a motion, and I believe Ms. Pearsall also filed a motion for scram monitoring. We did contact, I believe it was Lori, I believe my staff did, to let her know that at least our motion had been filed. So requesting us the scram monitoring, and I believe Ms. Pearsall, in addition, requested the patch. Well, I think she was saying, you know, like she was asserting her stance as well in denying the visitation, but in the alternative, if something were to be used, the patch, some patch.
Okay, Judge. Well, I think our motions speak for themselves.
And when was all this done?
This
Monday,
week.
Yeah, they were all filed this week. We both filed motions, and we also both filed proposed orders.
Okay. I had, except for a couple of pending oil and gas matters, I had my judge's queue cleaned out when I left Petula about 11:30 yesterday morning. So I'm logging on to see if there's anything there. All right, there's nothing in my judge's queue. I think I signed something early this week from this case. I don't remember.
Judge, would you like us to post the motions and the proposed orders in chat?
That would be a great idea.
Yes, but was it signed?
No, they're
I
just
signed something last week. I mean, early this week. Right. Let me open up the district clerk's records.
Hello, Judge. This is the district clerk's office.
Yes.
I have 2 orders in our queue. We accepted the motions, but we have the orders. We were pending, waiting to hear what you wanted us to do with those proposed orders. If you wanted them in e-file in your queue, or through the chat.
Well, since we're all already here, let's put them in chat, please.
So the motions on those orders should be in Odyssey. Those were accepted. It's just the proposed orders that I have in e-file.
Okay, but they were not sent to me. All right, if somebody would just please post all of that in chat. And Bobby Garza has signed in as Richard Alford.
Yes, and Dr. Alford is my witness, Judge, that I didn't get to on the last setting.
I thought the department went first in calling all of their witnesses.
And Mr. Alford was not available at that time, and he received the link today. So if I need him, he is present, and he should probably be placed in the waiting room.
Okay. Okay, Mr. Alford, will you raise your right hand? And actually unmute first. You solemnly swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
I'm sorry, and your name, please?
Richard Lynn Alford Jr.
All right. And I see Bobby Garza is here, and Ms. Garza was sworn in last week and put into the rule. Is that correct?
That is correct, Your Honor. That's the caseworker for the department. She's the party.
Okay, yes. All right. So, Mr. Alford, the rule has been invoked. What that means is that while you are, until you're released, you may not take any part of the hearing, and you can't monitor any part of the hearing unless you're actually in here testifying. Specifically, you can't do anything to find out or have anybody let you know what questions the other witnesses were asked, what answers they made to those questions, or what questions you may be asked. All right. You understand that, sir?
Yes, sir.
All right, then I'm going to place you in the waiting room until it's time to call.
Okay.
Okay, so do we need to look at the motions? Well,
Judge, all parties were served with the motions. For the sake of time and considering all of these extra witnesses that were not contemplated before, I trust the court to review those motions.
okay. All right, give me just a moment, and I'll be back.
Ms. Pearsall, can you put your response to the alcohol monitoring out to the judge, please?
It was the first one posted, Ms. Merritt, at 1:16 p.m.
Oh, I see it now. Thank you, Ms. Pearsall.
You're welcome.
All right, your first witness, ma'am?
Judge, I'll call Ms. Furman.
Okay, and Ms. Thurman, I muted you while the announcement was going over the speakers. So we can't hear you. You need to unmute your phone.
You better write that down. Thank you.
Go ahead, ma'am.
Thank you, Your Honor. Ms. Furman, state your name, please.
Jenna Furman.
And can you tell the court how you are related to this case?
I was originally the CASA case supervisor, and then when it was transitioned from the original CASA to myself, which was very rapidly, I became the direct CASA.
Okay. And so can you give the court the timeline of when that happened and how long have you been involved in this case?
April 2018.
Until today?
Yes, ma'am.
Okay. And what have you done in your role as CASA in this case?
I spent a great number of time visiting with Leslie.
Judge,
Can you hear me?
Judge, may I request that for the purposes of this hearing, we were supposed to restrict this testimony until the date of the last order up until now. And so if she's been there for that long, I believe, I would like specifically for her to identify the time and scope of her service post the final order in 2019.
I'm just asking her a background question as to what she has done. I'm not even seeking any specifics yet.
The objection is a good one, but I'm going to overrule it. Just, Ms. Pearsall, if you'll explain to your witness, after a brief background, what time period we have to be concentrating on.
Absolutely. Your Honor. So can you tell the court what you've done throughout this case and what connection you have specifically with the child in this case?
I follow Lexi's medical, her health, her education, and visit with the child, all the foster families, the family, as much as possible, and with the department to make sure that Lexi's well-being and overall self is cared for.
So let's move forward from 2019 until about December of 2020. Okay. During that period of time, was the child visiting off and on with her mother?
Yes, sporadically.
And some of those visits were virtual and some were in person, correct?
Correct. When they went virtual, I was not able to visit them, but I had to rely on Mrs. Dickey's reporting of her attendance.
All right, Ms. Furman, I need to interrupt you. Kimberly Lopez has checked in. Who is she? Is she a witness?
I'm the case manager
Kimberly
for
is
the
the
foster home.
She's not a witness for me, Judge.
She's not my witness either.
Yeah,
But she is the case manager for the foster home. She is the child placing agency who oversees the placement at the Hicks home.
let me rephrase my question. Is Kimberly Lopez someone who needs to be placed under the rule and removed?
No, Your Honor.
Well, but she's not a party to the suit. So if she's not a witness, she can watch on YouTube. I think that would be more appropriate. There's so many boxes already on here. I'm having a hard time keeping up.
I will just leave her muted for the time being. I have everybody on one screen. Go ahead, ma'am.
Ilana, can you rephrase the question? I'm sorry, I'm lost.
I can try. Okay, you testified that the visits were sporadic from 2019 until December of 2020. Can you explain why you said that?
When they went to the Miss Dickey overseeing the visits that were virtual, I wasn't able to observe them. And when they went therapeutic, when they were at Kid Share, I can't remember the exact date when they stopped at Kid Share, but then they would be scheduled at Kid Share, and then I would show up for a visit. The placement would show up, or Lexi would show up for a visit, and there would be no Laura. So it was very difficult to keep track of. It became very confusing.
Okay, and you're saying it was confusing because mom wasn't showing up for visits, is that correct?
She did not, and there would be a range of unknowns why. I don't remember all exact reasons, but she just wouldn't be there, and they were very specifically set dates for attendance.
And do you know what reactions, if any, Lexi had when her mother, in fact, did show up for visits?
When they were at Kid Share, Lexi would participate, but then she would leave. She would have outbursts in the parking lot, just like she was frustrated. She didn't know what to do. She didn't really want to be there. In fact, one day after that, she crawled in my lap, and she didn't, because I asked her, if you want to continue these, and she did not. I don't know what she specifically said to Miss Dickey because I was not in her presence. But
I'm sorry, did you just indicate that the child expressed to you she didn't want to continue visits? Did I understand that correctly?
Objection here.
She did not. She just. Okay.
Judge, we can't hear
Judge
you.
Wilson, you're on mute.
Sorry, I told you.
How did I get to mute?
Okay, there was a hearsay objection made, Ms. Pearsall.
Judge, I don't even know who said it. I was just trying to clarify kind of where it came from and it was hearsay or not. And the witness, I believe, already answered. So I feel like it was, a little too late of an objection.
You were asking this question. I'm objecting to the child, what the child told CASA.
I'll sustain the objection.
Are you aware that the visit stopped in December of 2020?
Hello, teacher. If you could enter your attendance for yesterday's date, please.
Who is
Tried to
that?
hit mute as soon as possible. I tried to hit mute as soon as possible. Someone else has come in. Yes, I'm aware visits were stopped.
And do you know what effect, if any, that had on the child?
Lexi is normal, happy, lucky go Lexi. She has not skipped a beat with those visits not occurring. She doesn't seem to miss Laura at all.
Objection, speculation.
Yeah,
Her
she's a child.
opinion.
It's her opinion, and she's a child's guardian ad litem. Judge, you're muted.
She doesn't ask for her to me. She doesn't bring it up, and when we're playing Barbie.
I'm sorry, I'm trying to keep muting because I keep coughing and sneezing. I'll overrule the objection. It's what the witness's observations are. Go ahead.
When we're playing Barbie, she doesn't bring it up. When we're reading books, she doesn't talk about it. She is absolutely well within her current location, is doing so well that it's just she has no lapse anymore from Laura existing. Bluntly, I don't know how to put it in another way. It's beginning to be crazy. It's beginning to be like she's just where she is, and she's extremely happy.
Now, you know, we are going to trial in about a month, give or take a week or two. Now, as
Yes,
this
ma'am.
as CASA, as this child's guardian ad litem, do you know what recommendation you're going to be making to the judge or jury, which you believe is in the best interest of Lexi?
I recommend that she be adopted by her current placement.
Okay, does that mean you recommend that Ms. Melvin's parental rights be terminated?
Yes.
And you understand today, Ms. Melvin is trying to challenge the prior court's order suspending her visits back in December of 2020, correct?
Yes, ma'am.
Okay. Do you have an opinion as this child's guardian as to what would be in this child's best interest in terms of either reinstating or continue to have her visits suspended?
I would leave them suspended due to her stability. Throwing additional visits at this time, this changing a therapist's opinion, in my opinion, to confuse. Oh no. I'm in a hearing. Can I call you back, Kathy?
Okay, well, I just need questions for you so you can get down here. Thank you.
Yes, ma'am. No confusion for Lexi at this point, and to keep her in the stability that she has with her education, with her therapist, with everything she has going on, I do not feel visits at this time would be beneficial.
Do you believe it will be harmful to Lexi in any way if the visits were reinstated?
I don't want her fearful again that she's going to be removed from her current family, who she refers to as family.
Okay. Thank you, Ms. Furman. I'll pass the witness.
Okay. Ms. Merritt?
Ms. Furman, you testified that you felt that she, meaning Lexi, did not want to visit with her mother. What gave you that impression?
When she crawled up in my arms and I asked her if she wanted them to continue that and or go live with Laura and Mac in Beeville.
And without stating anything that the child has ever said, do you feel that that was something that she wanted?
That she wanted just to not go to see mom, to see Laura
Yeah.
again, or to
live?
She did not want to live with Laura. She does not want to live with Laura at all. There is no question in my being that she wants to live with Laura.
When
with her actions, with her.
When you did see Visitation when there was an actual actual time that you were able to monitor the visit between Lexi and Miss Melvin, did you see a bond between Miss Melvin and Lexi?
Are we talking when we were holding the visits at KidShare?
At any point from 2019 until the visits were stopped?
There has not been a bond with Miss Melvin while the visits were at KidShare. She would play with her, but then she didn't know Lexi didn't know if you spend a lot of time with Lexi, you'll understand that Lexi didn't know what to do with Laura, and Laura, in my opinion, didn't really know what to do with Lexi. That was part of also the reasons that we went and got Miss Dickey, because it was very difficult to interact. They did not interact that well.
Thank you, Ms. Furman. I'll pass the witness.
Ms. Sims?
Ms. Furman, do you believe Lexi is an intelligent child?
I do. She's very bright.
Do you feel that she understands the dynamics of the foster home and her biological mother?
She understands the differences between the two. She has a definite separation between them, but I do believe that due to her diagnosis, and I am no medical doctor, that because she's so happy at times to just visit with people, depending on how something is phrased, she may get confused, but because she's such a friendly, outgoing child. But she definitely has a distinction between who is who and where she wants to be.
Okay. Has she specifically talked to you about Miss Melvin and her biological mother and siblings?
Yes. She knows the other brothers. She doesn't remember their names, but she knows she has other brothers, because I don't think she remembers them personally, but she remembers them in conversation, because Miss Melvin would bring pictures and then Miss Melvin would talk to them in visits. And she remembers them bringing her gifts and bringing her Barbies, because she would say in meetings and in visits, I have this Barbie already. So she knows how to compare the two locations by, I have that Barbie, I have that doll, I have those colors. So she was very distinct between the two locations.
Okay. And so in your communications with her and her knowledge of the two options of where to live, what is your understanding of what the child's desires are?
Lexi wants to stay with the current placement.
Okay. And specifically as to visitation and contact with Miss Melvin and the biological family, what is your understanding of what Lexi's desires are?
When I asked her last time, she doesn't really want to do this. She was more excited. She goes, oh, I get to go see Miss Judy again. Do you want to see your mommy? I don't want to see other mommy. I want to see Miss
Objection,
Judy.
hearsay.
So she, with desires.
Hold on, Jenna. There's been an objection.
I'm sorry.
And the judge is muted still.
I'm sorry, I keep forgetting.
Your Honor, I would argue that Ms. House's objection is untimely. The answer is already on the record when she made the objection.
I was objecting while she was talking. I believe it was timely.
I'll sustain the objection.
Okay. So, Jenna, let me rephrase then. Without telling me what Lexi says specifically, what is your understanding as to whether or not she would like to have visits with Miss Melvin?
I 100% believe she does not want those either, because when she does that, she clenched me in her arms and like she did not want me to let her go, to have to continue to do this or to move.
Okay. Thank you. I will pass the witness.
House?
Thank you, Judge. When you talked to Lexi, actually, when you were speaking to Lexi about her foster placement, what do you call Julie Hicks?
I call her mom or mommy.
Okay.
Because that's what Lexi calls her.
Okay. What do you call Mr. Hicks?
Dad or daddy, because that's what Lexi calls it.
What do you call Laura Melvin?
When I talked to her, I would say mom or mommy initially, until Lexi started saying other mommy.
Sometimes you would also use Laura, correct?
I don't think I really used Laura in front of Lexi, not to Lexi, because that's another third name, and that would not use Lexi. I would not say Laura in front of, with a conversation with Lexi.
So when you testified earlier about asking the child whether or not she wanted to live with Laura and Mac, are you now stating that those are pronouns that you did not use with the child?
No, I was trying to do that more for y'all's interest in who the people I was talking about, not specifically Laura and Mac.
When you talk to Lexi about Mr. Melvin, what do you call Mr. Melvin?
I don't really talk about him by name with Mac. I would refer to him as Mac if I'm having a conversation with answering your questions or something like that, so we know who we're speaking about.
When you talk to Lexi about her biological brothers, what names do you use for her bio brothers?
I don't even know their names. I don't remember their names off the top of my head.
Jenna, how
I just
many?
say your brothers.
Okay, you just say your brothers?
Your brothers. But they are her siblings.
Okay, and what do you call her foster brothers?
Her brothers, because that's what she calls them.
Prior to Lexi, actually, let me ask you, when did post the final order in 2019, when did you hear Lexi first use the word mom or mommy when it came to referring to Julie Hicks?
That was actually very early on in the case, and with I didn't really take it too seriously in the very, very beginning because children transition that, and sometimes they'll even call teacher mom. So it was wait until that we was watching them in their household and watching them at visits where I understood that was now who she understood to really be mommy. And
Jenna,
daddy.
Let me ask you, what does she call you?
Calls me Miss Jenna or Jenna.
When's the last time you've seen Lexi?
Physically seen her, not since COVID required me not to, but I've actually visited with her last night on the phone during a Zoom or Facebook call.
Oh, so you prior to last night by Zoom. When was the last time prior?
Sorry, it was Facebook. It was Facebook. Sorry.
Is it a Facebook audio or Facebook chat?
Facebook chat. I'm sorry. I'm so used to different Zoom and Teams and all sorts of names. It kind of gets confusing with me sometimes.
And this is a Facebook chat through whose account?
I end up using mine and the placements because that's the only way we can get to work because our phones get complicated with Google Duo. We have a bad connection.
And was it Julie or was it her husband?
Objection, Judge, relevance.
I'll allow the question for a bit more.
Miss Hicks connected it for us because Lexi's 5.
And in order for this to happen, are you all Facebook friends?
We have to be, yes. And in some situations, we haven't been able to get Google Duo to work where she's at and where we're at. It doesn't work in my location.
Okay.
I don't have the phone connectivity. That's why I'm at school today, still and working.
Okay, and one more question about this. How long have y'all been Facebook friends?
Objection, relevance.
Since we had to go to COVID.
I'll rule the objection.
Okay. Now, prior to the Facebook chatting, my question was, prior to last night, when was the last time you talked to Lexi prior to last night?
I visit with Lexi at least once a month. I don't remember the exact date. I don't have it in front of me.
And you are certain about this?
I'm absolutely every month.
And how long are these visits? Just with Lexi?
Just with Lexi? No, that's what I'm saying. So they can be anywhere from 30 minutes to sometimes for 45 minutes if we're in the bedroom and she's got her little camera going and she's playing dolls and we're reading. They could be upwards of 45 minutes. Okay. We have a really good time reading to each other and playing Barbies, and we play dress up, and she has a really good time.
Ms. Furman, were you present at the hearing when the visit stopped being at KidShare?
No.
Why not?
Because probably I was teaching.
Okay, is that your full-time job as a teacher?
Yes, ma'am.
what's the last hearing you've been present at prior to this hearing?
I started teaching July 29th this year.
When's the last time you've been present at a hearing prior to this hearing?
Objection,
The one
relevance?
prior to
Ms.
July.
Furman, wait,
The
please.
one prior.
Okay, hold on, ma'am. I'm sorry, what's the objection?
Relevance. We're here on one limited issue. I don't know how that matters when she was or wasn't present or was subpoenaed to be present at any hearing.
All right, Ms. House.
Judge, I believe it is relevant. She's representing, she stated in her testimony, that's when we decided to end the visits at KidShare. And so I want to know about what she's talking about.
Judge, I don't believe that's correct recitation. I think that was a response to my question when I asked what was she aware that the court decided or the judge decided.
And I think it's important.
I'll allow the question.
Ms. Furman, when was the last time you've been to a court hearing prior to this one?
The hearing, I believe the hearing before I started teaching before July 29th. I have not attended a hearing since July 29th of 2020.
Okay, but when was the last one?
Yes, I cannot answer that. Ms. House.
Okay, you don't know.
The answer is I don't know.
Okay, but to be fair, you've missed some, to be fair.
Yes, and my representation to Tyra represents what's in my court reports to the hearing.
Okay, and as far as visits with KidShare, you weren't in charge of organizing those visits, correct?
No, ma'am.
You're also not the point in contact to provide the information on KidShare visits to Laura Melvin, correct?
No, ma'am.
So if those visits were canceled, as communicated, okay. If it was communicated to Laura Melvin, I
apologize. Can you hear me? I went to mute real quick. Okay, thought it was faster.
If I'll answer. I didn't ask my question yet. Okay, I'm sorry,
Okay.
Ms. Furman. If it was communicated to Laura Melvin that a visit was canceled, you would know because you were not that point of contact, right?
No, the only person I had my communication through would be the caseworker, KidShare, or the placements on delivering, getting Lexi to the visit.
Okay. And how many times have you been to Laura Melvin's home?
The one in Beeville, never. She won't let me in. You stopped it. Before that, she stopped it and you stopped it.
You sure about that, Ms. Furman?
Yeah.
Ms. Furman, is that in writing somewhere?
It was in a text stream, and it was mentioned in a hearing, and Laura would never let me in. I know she told me she never wanted me to come in her house.
Okay. Ms. Furman, how many times have you been to the foster placements home?
Once a month.
How many times have you been to Lexi's school?
This one, none.
Okay.
It's about communication, communicating with her teachers.
Tell me about the behavioral problems that Lexi had while in the foster placements home in 2019.
Objection, Your Honor, relevance to the motion. You're muted, Your Honor.
Ms. House?
Judge, they were talking about behavioral issues faced with the child, claiming that it only happened with Laura Melvin, but I think that's been debunked since that point. And so I want to go into and ask CASA about her behavioral issues. They're stating that Laura Melvin should not have visits with the child because of her behavior. I want to know about the child's behavior.
Okay. I will allow that question to the extent the witness has personal knowledge after the date of the last final order.
Okay. Thank you, Judge. So Ms. Furman, after the date of the last final order in 2019, describe Lexi's behavioral issues.
And I want to confirm that is after visits have stopped.
No, ma'am. Visits weren't stopped in 2019. So what behavioral?
Clarify. Lexi has to keep a very, she keeps a very good schedule. If she doesn't keep that schedule, they're very focused on keeping that schedule. She gets very unhappy, has outbursts, little anger outbursts that are difficult to describe, but she's very defiant. It takes a little bit of time to get her back into not being as defiant.
Okay.
I've seen her very, very, very compliant, very responsive to the placement. And then when she was in the parking lot one day, she was very defiant. She didn't want to listen. She didn't want to do certain things. And that was not the child that I was normally used to seeing when separating myself from the placement and the visits, knowing, and it wasn't a defiance of after seeing other observations over time as well. It wasn't defiance that she was having to leave. It was like she didn't want to behave because they brought her there. The other way around, it was a flip. It was not based on a defiance of I don't want to leave, because I've seen that in other cases. But it was a defiance of why are you bringing me here? But she did like getting toys.
Miss Furman, but as soon as she stepped into the room with Laura Melvin at Kids Share, that defiance was not displayed in that room. Is that not true?
Lexi was very hesitant on several occasions when she walked in the room because she didn't know what to do. It was not like some magical light switch. When she walked in the room, everything was fine.
Okay. And then my question, Miss Furman, as soon as Lexi walked into the room at Kids Share to meet with Laura Melvin, she did not have a meltdown, yes or no?
Objection, Your Honor. The question was asked and answered. Because she didn't like the answer doesn't mean she gets to badger her with the same question.
This is a different question.
I will rule the objection.
Yes or no? Lexi did not have a meltdown when she walked into the room at Kids Share to meet with Laura Melvin.
Which date and what do you mean by meltdown? She didn't know what to do. She didn't have a screaming, yelling fit. No.
Okay. And then the visits at Kids Share, were they videotaped, ma'am?
I have no idea.
Okay. And can you describe what did the room look like at Kids Share?
We were in different rooms at different times. Some of the rooms had toys. Some of them had shelves. Some of them had bean bags. Some of them had little tables. It was just they were in multiple different rooms. They were not consistent from room to room.
Okay. And Ms. Furman, how do you know that that Lexi wasn't having an outburst in the parking lot after meeting with her mom because she didn't want to go back to the other mom, also known as Julie? How do you know without saying what the child said?
The expression on her face was clinging to the placement, and the expressions, her body language, she was ready to go somewhere else. She was ready to be out of that location. She had done what she was told to do because she needed to go to the visits because we had to get her there. She had to do those kind of things. She was, told that she would enjoy them. And then when they were over, she was ready to go on about her day. She was ready to leave. She grabbed a hold of Julie and was ready to go. It was not, oh, I'm throwing a fit because I want to stay and play with Miss Melvin. It was, I want to go and leave from here.
Okay, but those are your words, correct? I want to leave from here. Those are your words, correct?
Yes. On that instance, that on those several times, she would just cling on to Julie, like, don't make me do this.
No one had to uncling this child from Julie at the beginning of those visits, correct?
I don't remember her having. We would come in different doors at different times. No, at the beginning, it was not like this.
All right. And then since Kids Share visits stopped, let me ask you, when is the last time you supervised a visit? Actually, when is the last time you observed a visit between Laura and the child?
We were going to I wish I had that date in my head. we were headed to, it was right before a hearing in Carnes.
Is it almost a year? Would that be fair to say?
Yes, it's been quite a while because it wasn't the hot chocolate episode. It was one when Laura's hands were shaking. I believe Miss Mosier was also partly in that observation with me that day.
Okay.
Because we were on the left hallway, not in the right hallway. We were in the left hallway. That wasn't the hot chocolate day.
I know what stance you have already taken, and you've told the court what stance you're going to say on a final trial. I'm going to ask you to.
Objection, Judge. Sidebar.
Sustained.
Say, identify to the court a positive aspect that you observed between Laura Melvin and Lexi's visits.
Lexi liked the toys. Lexi would try to engage, and when they would engage, it was okay. She spent more time playing with Mac than with Laura. She spent more time playing with Hunter than with Laura. Laura tended to use Mac and Hunter as a crutch. Laura almost didn't at that point, didn't know what to do with Lexi. Lexi would play, she would bring her gifts. Once their gifts were opened, she didn't really play with her that much. The one that I remember probably the most that Laura actually played with with Lexi one time was with an ice cream game or toy. But there was not, almost like she didn't know how to play with her, or whatever she was going on in her life, Lexi wasn't the focus, even though she was in the room with her.
And Ms. Furman, did you ever provide what you're testifying to as of today, did you provide this feedback to Laura Melvin along with suggestions?
When I initially was with Laura, everything was fine. And then when she asked me one time, we did that, and I believe the therapist did it, but I haven't spoken to Laura in a growl because I was informed not to by Laura and Tess. I don't remember the exact.
Break it up. Okay, I need you to repeat.
I'm sorry.
Your last question. Go ahead. Your last answer.
I don't remember. I shared information back when I was allowed to talk to Laura. Laura did not want to communicate with me anymore. In fact, I guess if I had the date off the top of my head, I would tell you when you said through text and then email that we were not supposed to communicate with Laura, then you opened it back up, but then Laura will not communicate with me after several attempts, and then we're told not to do it again, or she was going to get an attorney on us. So it's been better to just not. So I have not, after that point, never communicated with Laura on how to be beneficial. That was then left up to the therapist for beneficial and how to improve her visits.
And Ms. Furman, what have you placed in writing to my client evidencing you providing suggestions on how to improve the visitation, how to improve visitation based on your observation?
Objection, Your Honor. It was asked and answered.
Wait.
Objection, it was asked and answered.
Same objection.
And Judge, I did not hear her specifically identify when she did that. She talked about when communication was shut off or resumed, but I didn't hear her answer this question.
Right. Ma'am, what's the answer to the question? Actually, we're going to stop right there. I'm home with my special needs son. I need to go and check on him. His brother's watching him. We'll come back at 2:10.
Thank you, Your Honor.
Okay, I'm back.
Thank you, Judge.
Go ahead.
No further questions. Pass the witness.
Ms. Pearsall.
Thank you, Your Honor. Ms. Furman, have you ever
Okay, sorry. I was just, go ahead.
That's
okay.
okay.
Overhead speaker.
Ms. Furman, have you ever personally been to KidShare?
Oh, yeah.
Okay. And does KidShare keep detailed notes of the visits?
I think they're somewhat detailed. I'm not sure they're as accurate as they need to be.
Okay, have you ever reviewed those notes?
On this case and on others, they are a little more generic and than they should be.
Okay, but my question is, have you ever reviewed the notes?
Yes, I have.
Okay, and you've also spoken to kid share staff?
Yes.
Okay, and you've also personally observed some visits, correct?
Yes.
Okay, so when you testify about the concerns you have during the visits, it's from not only information from other sources, but also reading as well as observing them yourselves, correct?
Yes.
Okay. Now, you started saying something during Ms. House's questioning, but you were interrupted about Laura's hands shaking. Do you recall that?
Yes.
Can you explain to us what were you trying to say before you were interrupted?
At one of the visits, when I observed Laura, when she would be trying to open up a wrapper or hand us plugged a toy, you could see her hands shaking, and I don't know the reason why, but they were shaking, which was evident because she also had to have Mac help her open it, and she couldn't end up giving the candy to Lexi. Actually, I believe Sonia was actually at one of those.
And you mean the child's attorney?
Yes. On one of the times her hands were shaking. I believe Sonia was at one of those visits.
What other?
We were actually,
sorry, go ahead.
This delay is hard.
What were you going to say?
It didn't just happen that one time. It happened on other occasions, but that one I remember distinctly because she was trying to open wrappers, and also another time when she had brought hot chocolate and handed Lexi hot chocolate, that the hot chocolate was still hot. So I was afraid I was afraid and told the kid share worker she can't hand her this chocolate.
Objection hearsay.
Spill it on her.
Objection hearsay.
I said it. I know what I said to the kid share worker.
Judge Wilson, you're muted.
I tried to unmute myself. I'm sorry. Okay. Ms. Furman, you need not to respond to the objections. I'll overrule the objection because I think it's correct. I did not hear any recitation of something the third party said.
Well, it's an out-of-court statement that she's saying to another person.
It's her statement, which is not hearsay.
To another person out of court.
Yeah, I've overruled the objection.
Okay, Ms. Furman, so what was your concern and what did you say?
I was afraid Lexi, when I said this paper, that Lexi was going to have hot chocolate spilled on her because of the shaking, and so I didn't want that to do that. And then also on the other visit, you could tell it was frustrating that Lexi was having to wait for that handshaking, and I didn't know what was causing the handshaking, if she would fall on Lexi or what would happen next. I know kid share is there, everybody's there to keep her safe, but I didn't want Laura to be that unstable that she would fall on Lexi and harm her.
Okay. Why were you concerned that Ms. Melvin would fall on Lexi?
Based on her history of either medical conditions and or her, I'm going to say alleged or actual abuse of prescription drugs and or alcohol. That's why we're in this case.
Okay. Did you have any other concerns that you haven't shared during the visits?
It was very confusing for Lexi, in my opinion, watching her not knowing how to respond and what to do because there was so much inconsistency with Laura's behavior and the structure of the visits. Even though you want them to go as natural and free flow as possible, it didn't happen that way. So Leslie was left with like an uncertainty on how to be. She's very much a loving child, and she didn't know what to do sometimes. And it was troubling to watch, especially toward the end.
Okay. And that's part of the reason that you think it would harm Lexi if the visits were to resume, correct?
Yes.
Okay. Now, you were asked about providing feedback. Your job as a CASA, is it to provide feedback to parents or to be there for the best interest of the child?
I'm there for the best interest of the child. If a parent were to ask me something, I would be happy to share with what I know because I want to be fair to all. But I'm there for Lexi. I am Lexi's advocate.
But you do provide CASA reports and file them with the court on a regular basis, correct?
Yes, ma'am.
And have you done that throughout this case?
Yes, ma'am.
And do you express in your CASA reports your concerns about visits?
Yes, ma'am. We have a whole section on visits.
Okay. And so throughout this case, have you been providing your concerns and your feedback about the multiple issues with parent-child visits in all of your CASA reports?
I can't, because I have been providing yes, sorry, something is in my eye, and mosquitoes. Yes, every one of them has a section filled out, completed.
And it would be fair to say that you had concerns throughout this case about, and let's stick from 2019 until December of 2020, about the inappropriateness of the visits between Ms. Melvin and the child?
Yes.
No other questions?
Ms. Barrett.
No questions, Judge.
Ms. Sims.
No additional questions, Your Honor.
All right, so may this witness be released?
Judge, I had one brief follow-up. I would be the last one because I think she was hold on.
Yes, go ahead, Ms. House.
Thank you, Judge. Jenna, you would represent to the court that your presence in observing visits between Laura and Lexi would be positive, correct? I'm
not following your question, Tess. Can you restate that for me?
Sure. You would represent to the court that your presence in the observation of visits between Laura and Lexi were positive, correct?
We're positive when? Me observing in another room? I'm not understanding the question.
Okay. The question is whether or not you find your presence observing visits between Laura and Lexi positive.
My presence. I'm in another room observing a visit, so I'm not understanding when you're saying by presence positive.
You were there prior to visits, correct?
Yeah, I'm in the visitation room most of the time, already in the visitation room prior to Laura going there. So Lexi is not tainted by seeing me first, if it's at all possible, not seeing me first to be there. So her first impression would be between Laura and Lexi, not me interfering at all. She doesn't even know I'm there.
Ms. Furman, you find that the information you provided as to visits you observed useful, correct?
I hope they've been useful to the judge and to Lexi.
Despite how hopeful you are that they have been useful to the court, your role when it came to observing visits was terminated when Judy Dickey came into the picture, correct?
In observing those visits, yes.
The role of the caseworker as well when it came to observing visits between Laura and Lexi was terminated when Judy Dickey came into the picture, correct?
That's my understanding.
Thank you. No further questions.
Anything else from this witness for anyone?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Also, may she be excused?
Yes, Your Honor.
Yes.
Thank my principal appreciates that.
You are excused.
Thank you, Mr. Thurman.
All right, your next witness.
I'll call Dr. Alford. Dr. Alford, please state your name.
My name is Richard Lynn Alford Jr., and I'm a MS LPC. I'm not a doctor.
Oh, I apologize.
Okay, just want to make sure.
Can you tell this court what educational background you have?
Educational background is a master's of education in the field of counseling, received in 1999.
And so what have you done for the last 22 years after you got your master's?
After that, I periodically did work with family counseling service here in Corpus Christi and with the Council on Alcohol and Drug Abuse, obtaining hours for my internship. In 2003 is when I applied to for the test, to test after I acquired my hours, and been working with CPS clients since 1999, off and on from 1999 to like 2003 while I was obtaining my my hours. And then in 2008 is when I applied to contract with the state as a sole proprietor. And so I've strictly been doing that. I'm working in Beeville since 2006 to the present, and strictly CPS clients.
And so what type of counseling do you do with clients? Is there some specific subfield that you're in, or is it counseling on all issues?
It's pretty much counseling on all issues, but it's primarily the modality I try to use is a rational emotive behavior therapy. And of course, the state requires us to go through training in reference to evidence-based and trauma therapy. But it's pretty much, I've worked with domestic violence clients, drug and alcohol, couples therapy, family therapy, depression, anxiety. So pretty much it's a wide variety. Whatever the client is in need of, that's what I have to address.
At this point, I would ask that Mr. Alford be admitted as an expert in counseling and drug counseling.
No objection.
I don't know about the drug counseling. I'm not sure that you laid the proper foundation for that. But outside of, him being in his field in counseling, I don't have any objection to that. So for the limited purposes. Oh, Judge, you're mute.
Sorry, Ms. Pearsall, are you planning to elicit testimony about drug counseling?
I can, Judge.
I'm not asking you to, but so, all right, I will admit Mr. Alford as a witness for counseling and drug counseling.
Thank you.
And overrule Ms. House's objection on that. Go ahead, Ms. Pearsall.
Mr. Alford, even though the judge already admitted you, can you just explain to the court how many years have you been doing drug counseling with patients?
It's been approximately 22 years.
Okay. Okay. How are you familiar with Ms. Melvin in this case?
How familiar am I with her?
How do you know her?
Oh, the state sent what they call a 2054 to me, which is an authorization to begin counseling and therapy back in January of 2019. Okay. And that's when I started the counseling. It wasn't, it was counseling. They sent her for counseling and parenting.
Okay. And so you were supposed to, she was supposed to engage with you in counseling and parenting back in January of 2019?
Yes.
Okay. And how many parenting sessions should she have had?
She usually, once they attend 12 consistently, then I begin to reevaluate if they need any more, because it's a parenting class / group. So it's still therapeutic. So I have them doing certain things to address, healing and repair or mending relationships. So she attended 11 total.
She's attended 11 total from January 2019 until today?
Not until today. We've been, in the last 2 months, we've been addressing a few parenting issues in the one-on-one. But the actual class back in 19, she went to 11 classes.
And how long does it typically take a parent to finish that parenting course?
Well, it's 12 major topics, so 3 to 4 months.
Okay, so what should have been taken 3 to 4 months, which would have gotten us to April or May of 2019, still hasn't been finished in May of 2021. Is that correct?
I don't want to say it hasn't been finished, because we've addressed whatever else needs to be addressed in the group, and it's up to my discretion. Sometimes if they have a good handle on how to nurture a child, then 10 or 11 is good for me. And then I do like just a few sessions of the individual just to go over the topics, and then to review a post-test or post-survey that I give them.
Have you ever observed Ms. Melvin at a visit with her child?
No.
Okay. So you don't have any basis to form an opinion as to whether or not she has learned the benefit from your parenting class, do you?
Objection, leading. Judge Wilson. I'll just withdraw my objection. Oh, did he disappear now? He's gone.
Okay, you all hear me?
Yes.
All right, I'm back. I missed, I'm not sure how much I missed. I missed a question or two, I guess.
Judge, we realized you were gone and we stopped. I guess what was the last thing you heard?
You were asking, there was a testimony from Mr. Alfred about how sometimes after 10 or 11 sessions instead of 12, but if the person gets it, that he'll switch to individual counseling.
Okay, thank you, Honor. Mr. Alfred, have you ever observed Ms. Melvin visiting with her daughter, Lexi?
No.
Okay. So you don't know from personal observation whether or not she has learned how to properly parent, do you?
From personal observation, no.
Okay. What kind of counseling were you supposed to be administering to Ms. Melvin from starting in January of 2019?
It's called psychotherapeutic counseling. So it's addressing what I usually put on the treatment plan is addressing why they're involved with CPS. And then I'll do a few assessments to see if they need to address anxiety, depression, drug and alcohol, trauma. And then a lot of times on the treatment plan, of course, there's going to be parenting involved because we're working with children. So those are the types of issues that I'm required to address with them.
So what did Ms. Melvin's treatment plan require her to address?
First of all, it's always going to be why they're involved or what pre-stressors led up to CPS involvement. Secondly, it's always going to be about parenting, whether it be their approach or how it applies to the developmental stage of the children. And then stress is always going to be on the treatment plan as well. And then of course, a lot of times the fourth or fifth treatment plan is going to be in reference to addressing principles of therapy and just principles of therapy and some of the principles that I like to address in the parenting or that I feel is needed in the parenting.
Okay, so specifically to Ms. Melvin, which was my original question, what was her treatment plan? What did she need to address? Which issues?
It was the issue of why CPS is involved.
Okay, why is CPS involved in her case?
Why is CPS involved in her case?
Mm-hmm.
Because they were questioning her ability to protect Lexi. And being under the influence of alcohol.
Okay, so you're supposed to address with her the issue of being protective and the issue of her alcoholism, correct?
Yes.
Any other issues you were supposed to address with her in therapy?
That's it. Just individual. They wanted individual counseling, parenting, and drug and alcohol, addressing drug and alcohol issues.
Okay. And what drug and alcohol issues did she have that you're aware of?
Well, it wasn't drugs. It was, unless during the education we discussed alcohol could be considered a drug, but it's mostly just alcohol and drinking and how that could affect her performance in reference to in care for Lexi.
So when you got that initial 2054 in January of 2019, how often was Ms. Melvin supposed to attend therapy with you?
It's supposed to be weekly. And then after talking with clients, if they need biweekly, then it'll be biweekly. But initially, it's supposed to be weekly.
Okay. So in January of 2019, how many of the weekly sessions did Ms. Melvin attend?
Ms. Pearsall, I'm getting, I don't know if everyone else is, an echo on your end. I just want to make sure, is there anyone else in your office or around you who's listening to this and has a speaker or something on?
Not that I know of, Judge. I can close my office door, but my assistant doesn't have she doesn't have anything on. You want me to try that?
I don't know if other people were hearing it, but I was getting a definite echo.
Did that help?
Yes, go ahead.
Okay. Ms. Alford, in January of 2019, how many sessions did Ms. Melvin attend?
Let's see. 11?
In January?
No.
In January of 2019, how many sessions?
Oh, in January, I'm sorry. It was a 2.
2. So she missed 2 and attended 2.
She didn't miss 2 because the authorization didn't come in till the, well, let me give you a specific date. But the 2 dates that she did attend was 1/23 and 1/30.
Okay, so she attended both after the authorization came in.
Yes.
Okay. What about February of 2019?
February, it was 1, 2, 3.
Okay, so in February, she attended 3 but missed 1?
Yes, but one of those was a 2-hour session, so it was 4 sessions in the month of February.
What about March of 2019?
That was 2 sessions.
Hold on. Ms. Cavazos, are you able to hear?
Judge, it's echoing.
Well, and you are too. I don't know if. All right. Let's try it again, Ms. Pearsall. If you'd repeat your last question.
Okay, I think you said in March 2019, she attended 2 of the 4 sessions. Is that correct?
Yes.
Okay. What about April of 2019?
She did not attend in April.
Okay, so she missed all of the sessions?
Yes.
Okay. What about May of 2019?
May, she attended 1 session.
And missed 3?
Yes.
June of 2019?
1 session. It's a 2-hour session.
I'm sorry, she attended 1 session or she missed 1 session?
She attended 1 session.
Okay. July of 2019?
0 sessions.
0 sessions attended or 0 sessions missed?
0 sessions. Missed. Let me check. 2019. I'm checking the 2054. Okay, I don't have a 2054 for August. I only have it up to July.
I'm asking you about July.
Yeah, so July I had my 2054 only goes to the 3rd of July, so there was no sessions attended in those 3 days in July.
When did you get the next 2054?
I'm showing 1/24/2020.
Did Ms. Melvin attend any sessions in January of 2020?
No.
February of 2020?
I'm sorry?
February of 2020?
February, no.
And we're still talking about weekly sessions she was supposed to attend, correct?
Usually if there's an open 2054, they're supposed to come weekly, yes.
Okay. And you would agree with me that she knew exactly how to contact you and how to attend and how to make an appointment since she was supposed to do it and in fact did it for a little bit in 2019, correct?
Objection leading.
Sustained.
Are you aware whether or not Ms. Melvin knew how to get in contact with you and schedule an appointment?
I'm sorry. You're asking, I'm sorry, can you repeat that question?
Sure. Do you know if Miss Melvin knew how to get in touch with you and schedule an appointment?
Yeah, it was the same number.
Okay. So after she chose not to show up in January or February of 2020, did Miss Melvin come in March of 2020?
No, but I don't know if we want to blame COVID on that one, but no, she didn't.
What about April of 2020? Did you have any sessions at that point?
No.
May of 2020, did you have any sessions?
Okay, in the interest of time, Ms. Pearsall, would you please just ask the witness what additional sessions, if any, were held?
Can you tell this court when Miss Melvin actually chose to show up for her first session from, I guess, January of 2020? When was the first time she actually showed up?
Well, according to her, she was going through some COVID testing, and then she.
Alfred, that wasn't my question. My question was, when did Miss Melvin actually show up to a session with you? From January of 2020, when did she actually bother to show up for her first appointment?
Objection, argumentative. When did she bother to show up? I mean, it's just.
I'll overrule the objection.
We began a few Zoom sessions in September.
Of 2020?
2020, yes.
Okay. Has she had any missed appointments in September of 2020 until today?
There was approximately 3 missed sessions due to other conflicting doctor's appointments, but she would always contact me and let me know she couldn't make it.
Now, would you agree with me that therapy is only effective if the person with whom you're doing therapy is honest with you?
Objection leading.
I couldn't actually understand most of the question. Ms. Pearsall, I'm going to ask you to log off and come back in. I don't know what happened. You were not echoing when we started, but you are now, and it seems to be getting worse, at least on my machine. So I'm going to ask you just to log back in and let's try it from here.
Okay. Yes, Your Honor. Is this any better?
Can't tell. All right, go ahead.
Mr. Alford,
No, it's much worse. It's much worse.
Are
you certain there's no one else at all with this going on Zoom, on YouTube, or anywhere else in your office?
Your
No
Honor,
one, Judge.
it may be if some of the parties don't have themselves muted. I know the attorneys are unmuted to make timely objections. Perhaps if you would allow us to make a motion to stop testimony, and then we can keep ourselves muted, and maybe that would cut back on some of the feedback.
And I don't know if that's the case, but sometimes with cell phones and other gadgets being by your technology, that could cause interference as well.
All right, Ms. Pearsall, are you on a phone, or are you on a PC or laptop? Or?
I'm on a PC, Judge. Same PC I'm always on. I can walk out of my office and use my cell phone if that helps.
Right now, it's fine. All right, well, everybody's muted except you and I. So let me mute Mr. Alford. Let me mute myself, and I'll ask the attorneys just to wave your hands if you have an objection and/or have your finger on the unmute button.
Mr. Alford, is therapy, in order for therapy to be effective, does the patient need to be honest with you?
That would help, yes.
And what you're telling this court is from January 2019 until today, based on your counseling sessions with Miss Melvin, you're under the impression that her only addiction is alcohol?
At this time, she's not showing any other behaviors or items to be addicted to.
Mr. Alford, that wasn't my question. My question was, has Miss Melvin ever disclosed to you her addiction to anything other than alcohol?
In the past, I believe she discussed some addiction to certain pills. I don't remember which ones, but yes.
Okay. So she admitted to you that she was previously addicted to pills,
Yes.
but do you know how long ago that was?
No, I don't.
Do you know what pills those were?
I couldn't tell you right now, no.
Don't you think that's something that's important to know in order to be able to address it in drug counseling?
Sometimes.
Has she ever been addicted to anything other than pills?
Not that I'm aware of, no.
Did Ms. Melvin ever disclose to you that she was addicted to hydrocodone?
I can't recall on that one.
Did she ever disclose to you that she was addicted to benzos?
Objection asked and answered. She's already asked him what pills he recalls, and he already stated that he couldn't recall.
It's a different question, Your Honor.
Objection asked and answered. Oh, Judge, you're muted.
Overruled.
You can answer, Mr. Alford. Did Ms. Melvin ever disclose to you that she was addicted to benzos?
I don't recall that, no.
Okay. So from what you know, she has never been addicted to benzos. Is that correct?
From current recollection, you're correct.
Okay. Would it surprise you to know that she was still on benzos as recently as a few months ago?
Yeah, I'd be a little, yeah, I'd be surprised. I'd be concerned about that, yes.
Would you be surprised to learn that she was on way too much benzos the entire 2019 and 2020?
Objection, facts not in evidence, and that's a misrepresentation of the evidence.
Judge, I'm asking him a question, and those facts are in evidence from Dr. Miller's testimony.
That is incorrect. It's a misstatement.
Wait, what was the question?
Would it surprise him to know that she was on way too many benzos throughout 2019 and 2020?
Objection, that's a misrepresentation of the testimony.
He's an expert, Judge. I'm just asking if he's aware.
I have to go back to look through my notes. I don't know if they're that detailed. I'll overrule the objection, but I'm not taking that as that this is the correct representation of Mr. Miller's testimony. Go ahead.
You can answer, Mr. Alford.
Yeah, the word, I wouldn't use the word surprise because nothing surprises me with the client. So, but as far as if I was aware that she was taking those, no, I wasn't aware.
I'll pass the witness.
Ms. Barrett? You're muted.
Thank you, Judge. I apologize. Good afternoon, Mr. Alford. My name's Shelley Merritt. I do have a couple questions for you.
Okay.
My first question is, since January of 2021, how has Miss Melvin's how's Miss Melvin's attendance?
It's a lot more consistent, and she's been in contact with me. It's been better, so it's a lot different than before.
So, is she making every single appointment, all 4 sessions?
She's actually doing more than that. I asked her if she's willing to do 2 sessions a week, and she was willing to do that. So she's making more than the 4. So we've had approximately 8 sessions in the last month and a half. I had to take a week off, so it was a little bit more. Yeah.
Prior to a month and a half ago, so in January of 2021, was she doing sessions with you?
No, she was trying to set an appointment. I had to wait for a 2054, which is that authorization, but she was still in contact with me.
So, And how do you receive your 2054 authorizations, Mr. Alford?
It's usually through an email from the caseworker.
And so when did you allegedly receive the 2054 for January of 2021?
That was, well, the print date on the 2054 says 3/10/2021.
And are you stating that you hadn't received a 2054 before March of 2021?
Correct.
If
Ms. Mary, just for my benefit and maybe to save some time, Mr. Albert, was there? I thought you had mentioned 2054. Is it earlier? Was this a new one? Was it an extension? Was it a change, or was this the first one you ever received?
Judge, this one is an extension. They're only good for 3 to 4 months, so this one's an extension.
Go ahead, Ms. Mary.
so, and Mr. Alford, are you sure that you didn't check your junk mail or anything like that? Because you're aware that during that time period, the department did change their email address.
I'm aware they changed their email address. Checking the junk mail, I didn't do that.
So it is possible that you received the 2054 continuations, but they were in your junk mail.
It's highly unlikely. There's never a 2054 in my junk mail.
Well, that's funny because I've gotten court notices in my junk mail, and I don't purposely put them there either.
Objection, sidebar.
Mr. Alford, at this time, do you believe?
Ms. Merritt, the judge was raising his hand to my objection.
I just said sustained.
May I inquire?
Yeah, it was an objection to a sidebar, so yes, go ahead.
Mr. Alford, when did you double up on Miss Melvin's therapy?
It looks like it was May. We started to do a few more sessions. It just May. So we started back up 4/26. Then we had another session 4/28, then 5/3, and then let me just get that next date for you real quick. 3, and then
5/3.
we had to reschedule 5/5. And then the week of 5/10, I was out of town. And then the next session was it was a double session, 5/17, and then there was 5/24, and then this week we met twice as well.
So this week meaning 5/24, and when else?
I'm sorry, repeat that.
So the double sessions are just 2-hour sessions, is that correct?
It's either that or it's twice a week. So this week we did two. We did 2 in the week. And she's willing to continue doing that for as long as it takes.
Thank you, Mr. Alford. I have nothing further.
Ms. Sims,
I have no questions. Thank you.
Ms. House.
Mr. Alford, let me ask you, what exactly has Laura Melvin learned through your sessions?
She's She's learned about, of course, parenting. She's also learned the principles of addiction and recovery. She's learned, and within recovery and the 12 steps and the meetings she's going to, it's a spiritual program. So when one of my clients has a spiritual understanding, well, then that's the direction we go in as well. So learning to take it one day at a time, and of course work the steps, which she's doing already. And so she's learned those things, but it's my impression and my understanding that she already knew all this. She's an intelligent young woman, and she knows what to do. She hit a few bumps in the road, and she has a good, rational and nurturing understanding of how to parent a child.
And prior to me asking you what she's learned today, has the department ever approached you to ask you, has Laura Melvin gained skills from your session to adequately parent a child?
I haven't received that question. It's mostly just, is she attending?
Do you believe that it would have been beneficial for the department to ask you what she was learning from a service that they themselves set up for Laura Melvin?
Oh yeah, I would. I love when they ask me those questions, because it challenges me to really, dig deep and see if they are, internalizing the information and then applying it.
So, and excuse me, and Mr. Alford, how long have you been working as a service provider for the Texas Department of Family and Protective Services?
First case was in 1999. It's been consistent since 2005. So consistently as a full-time job, 16 years, off and on from 2005 from 1999.
And throughout the time that you have provided services as a counselor to parents involved with the Texas Department of Family and Protective Services, has the department ever complained about the services you provide to parents?
In Beeville, no. When I was first starting out, there was one caseworker that didn't appreciate a referral from an outside agency to come and help his client.
Okay. So that would have been over like 16 years ago?
Oh, yeah. Yeah, that was when I was first starting. Yeah.
And in fact, you're not a contractor that Laura Melvin found herself. You are a provider that the department found to service this case, correct?
Correct.
And as it stands today, I just want to go over what you were contracted to. And let me ask you, is it your job? You don't have a psychiatric degree, correct?
Correct.
And it's not your job to provide medication management for any person that comes to see you. Is that not also correct?
Correct.
And so if a patient is prescribed benzos, it's not your job in order to second guess that prescription, right?
Right.
At any point in time, did the department, let me ask you about the 2054. Actually, let me ask you, how many times have you spoken to the caseworker, Bobby Garza? If you recall.
Spoken like verbally over the phone?
Sure.
I want to say I'd be maybe once. It's usually just through email or text.
And in email and text, has she ever provided you any feedback as to what other services can be provided to Laura Melvin?
Not that I recall, no.
Has she ever has the department ever told you that they believe that Ms. Melvin is not on target when it comes to services through your office?
I've never heard those words before, no.
Okay. As it stands today, where do you believe Ms. Melvin is as far as it relates to engagement with services through through you?
She's doing exceptional because she's contacting me. She's making her appointments. She's thriving in her recovery.
Now, not only do you see Laura Melvin, you also see Mac Melvin. Is that not correct?
Not as many times as I've seen Mrs. Melvin, but I've seen him a couple times.
And during the times you see Mac Melvin, what is the scope of that interaction?
He seems to be a caring father, stepfather, and in communicating with him, he seems like he has empathy for Lexi. He's hung in this long with Miss Melvin and helping her, so he's not afraid to help and to service and to provide help or to be of service, which is one of the love languages that I talk about. So I don't see any inappropriate behavior in him. He's always been very cordial with me, very polite. He's rational when I talk with him. So I don't see anything that would be a risk or a detriment to Lexi or Miss Melvin in his behavior or communication.
I'm glad you brought that up, Mr. Alford. Currently, you stated that there are no risks as it relates to Laura Melvin parenting a child, correct?
Correct.
There are no risks with Mac Melvin parenting a child, who's her husband, correct?
Not that I see, no.
Currently, are there any dangers as it relates to Laura Melvin parenting Lexi?
I don't currently see any today, no.
Are there any dangers as it relates to Mac Melvin parenting Lexi?
No.
And you are aware that Laura Melvin, in fact, parents unsupervised biological siblings of Lexi as it states today, correct?
Yes.
Okay. And let me ask you, Mr. Alford, because I want to follow up with something Alana Pearsall asked you. How many times has the department contracted you to supervise visitation between a parent and their child?
That's not in my contract.
Okay.
To do that.
Got it. So you don't believe you should be penalized for not having observed Lexi's interaction with Laura Melvin, correct?
Correct.
Do you provide that service outside of your contract?
No.
Okay. Thank you, sir.
You're welcome.
Let me ask you, Mr. Alford, what else do you have left to work on with Laura Melvin?
She's doing really well these days. And as long as she keeps up with her recovery, it would be just to follow up with how she's, sometimes when clients do get their children back, I'll continue to see them just to see how things are going, how the adjustment is going. So that would be it. But Ms. Melvin is doing good these days. She's doing really well.
Would you be, Mr. Alford, do you believe that it is healthy to accuse a person who is on the road to maintain sobriety as a person that has relapsed without evidence? Is that healthy?
Objection, relevance.
Yes, Judge. This has come up in this case, accusations allegedly that Ms. Melvin has relapsed. And I'm asking whether or not I would like his feedback as to this treatment of my client.
I would object as it's irrelevant. And I think what Ms. House is referring to is that the fact that her client passed out, and that's not an accusation, that's her drunken behavior.
Judge, I would like that stricken from the record. There is no evidence that fallout had to do with a relapse or lack of sobriety. And how defamatory, Attorney Pearsall?
Okay, I'll overrule the objection. Let him answer the question.
Mr. Alford, do you believe that it is healthy that persons accuse? Actually, can I ask the court reporter to repeat?
Actually, Ms. House,
sure.
Of course, false accusations of relapse are not healthy.
Okay.
I don't know if that's happened or not, but of course that's not healthy. Please move on to something else.
Mr. Alford, based on your interaction with clients, with Laura Melvin, do you believe that she has relapsed in any way?
Objection calls for speculation.
Overruled.
You can answer, Mr. Alford.
Oh, no, I don't believe she's relapsed since the time she stopped and started her recovery.
Okay.
But then again, relapse is part of people's recovery. And even if she did, she stayed in. She didn't stay out there, which means if that did happen, she continued to use the principles of sobriety and stayed clean. But I don't believe she was drunk that day either. Just the same.
The 2054 currently that you're operating under, Mr. Alford, when does that expire?
I believe the 30th. Let me just 31st. So Monday.
Of May.
Yes, Monday of May of 2021.
Have you been given an extension by the Texas Department of Family and Protective Services?
Not yet.
Okay. If you don't receive that, would you still be able to double up on those sessions next week, even outside of a 2054?
Not supposed to. Not supposed to see them unless I have the 2054.
Okay.
If there's an emergency, I'm not going to deny going to see her if there's an emergency, but I'm not supposed to continue service unless I have the 2054. But ethically in my license, if there's an emergency crisis, well, yeah, I got to.
And then as far as the extension of the 2054, are you supposed to receive another 2054 prior to the termination of the 2054 or after the 2054 expires?
I'd have to look at my contract, but it usually never, well, I don't want to say that, but no, I'd have to look at my contract and see, but usually if it expires, I have to usually, unfortunately, remind the caseworkers to renew the services.
Okay.
That's all across the board.
And as of today, has Bobby Garza contacted you to renew this soon to expire 2054?
Not at this time.
Okay. And if I made a request to the court to order the Texas Department of Family and Protective Services to renew the 2054 and extending services to Laura Melvin, would you be on board to continuing giving services to my client?
Yes.
Thank you. No further questions. Pass witness.
Okay, before we go any further, I need to check on my son again. I'll be back in a moment. Well, actually, let's call it 10 minutes, 3:25. Folks, I'm on the phone with the police department about a search warrant. I'll be back as quick as I can. Okay, I'm back finally. I thought perhaps I was being ex parte because I looked down at my little tracker and it has who called on, was calling on there, and it said Pearsall, but it was the Pearsall Police Department. It was this very odd coincidence that the Pearsall PD would call when we wrote a break in this case, but I've got that done. All right, Ms. Pearsall, do you have any more questions for this witness?
I feel so blamed. Yes, Your Honor. Mr. Alford.
One moment. I don't see my client. Let me call her.
Oh, she's in the breakout room or the waiting room.
Okay. Thank you, Judge.
Go ahead.
Okay. Mr. Alford, you testified earlier that Ms. Melvin finally engaged in therapy in September of 2020, correct?
Yes.
Okay. And when did her husband engage in therapy?
He engaged back in 2019. He attended 3 of the parenting classes, and I did one session with them together. And then he joined us this past Wednesday.
Okay. So you've seen him 5 times since 2019?
Yes.
Okay. And has he been able to come to, well, all the sessions that Ms. Melvin at least showed up to since 2019?
He as far as showing up, he didn't show up as a client or for a session, but he's always been there.
And by always been there, you mean he's been there 5 times since 2019?
Oh, no, when I mean always been there, like, let's say this last 2 months, he usually opens the door for me to come into the house.
Okay.
But not in the sessions.
Okay. So that was actually going to be my next question. So those sessions you come to Ms. Melvin's home to do?
Yes.
Okay. So Ms. Melvin actually doesn't have to do anything to come to you. You kind of doing all the traveling and all the hard work. Isn't that true?
Objection, sidebar, objection leading.
You're muted, Your Honor.
I'll sustain the sidebar. You may answer the question, sir.
I go to her. Yes.
Okay. And since September of 2020, when you've gone to her, she's always been there and let you in and attended every session except 3, correct?
No. In September, I've been doing the home visits. That was starting 4/26 to just 2 days ago. That was going to the home. The other ones were Zoom meetings.
Okay. So she had to push a button and get on her phone, and then she could have a counseling session prior to April 26th, correct?
Objection, compound question.
I will rule the objection. And I'll state, I know I'm familiar with what it takes to log on to a Zoom meeting. And for the interest of time, I ask you to move on to something else.
Judge, can you enable share screen, please?
I don't have it shut off.
Oh, I apologize. Thank you, Judge. Mr. Alford, do you keep track of your therapy sessions in notes?
In notes that I send to the caseworker, yes.
Okay, and are those monthly session summaries? Is that what they're called?
Yes.
And have you been doing that in this case?
Yes.
Okay. I am going to share with you your monthly session summary from September of 2020.
Okay.
Can you see my screen?
I'm going to object to the publishing of a document. I'm going to object to hearsay.
Judge also has his therapy notes, and I need him to identify them in order to get them into evidence.
And I haven't seen this. I wasn't provided what Ms. Pearsall was going to present to the court prior to now.
Okay. Ms. Pearsall, have you provided this to all the other counsel?
Judge, there's been no discovery done in this case. I know the worker in this case kind of sends out, I think, an email or a text or a document every time anybody sneezes in this case. I can't swear to you that she sent this out, but I know she sends everything out.
Okay.
And these are his notes.
Everything out. You know she sends
Okay. I want to emphasize to all of the attorneys, this is the sort of thing that ought to be taken care of in advance. I mean, when you're trying to admit bank records, telephone records, therapist notes, all of that, we ought to know in advance if there's an objection or not, and not have to stop and look. So I'll ask Ms. Pearsall, you can post it in chat or whatever to this house, send her a copy of whatever it is you're trying to get admitted, and give her a moment to look at it.
Judge, you want me to send it just to Ms. House?
Don't care if anybody else is going to object, I'll just send it to them.
Okay, well, I think we figured out last time I can only send it to everyone or to Ms. House. So I just want to make sure what the court's order is.
I've already received them. I think that the ad litem's probably already received it as well.
I have
Even
all of the therapy
caseworker
notes.
sent them out, but
Ms. House, do you have any objections?
reviewing. No objection.
Okay, so what exhibit number are we up to? Ms. Pearsall?
Judge, Judge, I think it's second because I think the transcript was the first one, so I believe it's second.
All right, it's admitted as foster parents number 2.
Okay, Mr. Alford.
Yes.
These are notes from September of 2020, correct?
I'm sorry?
These are your monthly session summary from September of 2020, correct?
Yes.
And do they indicate that there were 4 appointments and Ms. Melvin didn't show up to any of them?
Correct.
Okay. So when you previously stated that she was present at all appointments, but 3 starting in September, that wasn't accurate, was it?
Correct. It wasn't accurate. It was my mistake.
Okay. Now I'm going to show you, it helps if I hit the right button. Do you not recall that you also didn't attend any sessions in October? Or do I need to show you that?
No, I don't think she attended in October. I'm looking at our text conversation. She was trying to set an appointment, but looks like we didn't have one.
Okay, so she also missed all of her sessions in October, unlike your prior testimony, correct?
Objection, that's a misrepresentation of his testimony.
No, it's not, Judge. He testified she's only missed 3 appointments since September, and so far he's admitted she didn't show up to any in September or October.
I'll overrule the objection. I'm not taking that as a ruling that the characterization is correct.
So, Mr. Alfred, is that
Yes.
correct that she didn't attend any appointments in October?
Correct.
Is it also correct that she didn't attend a single appointment in November of 2020? And if it helps, I can include.
I'm going to object to hearsay. I've not seen this document.
Yes, you have. It was texted to you through chat.
I have September.
You
Alana.
also have November. Look in chat.
Well, I haven't seen it to approve it. So you just
okay.
345.
How many chat documents did you send over, Ms. Pearsall? One with everything or multiple ones?
2.
She
I sent
sent
one in September and one was November about 2 minutes later.
2 minutes ago. You sent the
Okay.
November.
Do you have it, Ms. House?
I have it right now.
All right. Let us know when you finish reviewing it.
Thank you, Judge. No objection.
Go ahead, ma'am. Go ahead.
Your Honor, I'm asking that this be admitted as interveners 3.
Okay,
Mr.
without
Alfred.
objection, interveners 3 is admitted.
Thank you, Your Honor. Mr. Alfred, is it or is it not true that Ms. also didn't attend any sessions in November of 2020?
Yes, that's correct.
Okay. So that prior testimony was also incorrect. Is that right?
It looks like it, yes.
Okay. And is it also true that she didn't attend a single session in December of 2020?
No, that's not true. She attended one.
She attended 1?
Yeah.
And she missed 3? Is that correct?
I don't want to say that those were scheduled. I got to see if they were scheduled. So if she misses, if they're scheduled, then that she misses. Yeah, they're supposed to be weekly, but sometimes I don't hear from clients and I don't contact them so that there's no scheduled appointment.
Okay. So in December, she scheduled and showed up virtually for 1 appointment, correct?
Yes.
Okay. And when in December was that?
That was the first at 3:00.
December 1st?
Yes.
Okay. And then there were no more sessions for the rest of December of 2020, correct?
Correct.
Okay. In January, would it be fair to say she didn't have a single session with you, January of 2021?
Yes, that's correct.
So again, when you said she was attending regularly, that wasn't true, was it?
Well, that's when you ask that question. I mean, that's the regularly was from she started back up 4/26 to now she's been regularly attending.
Okay. So she's been regularly attended when you started showing up at her home on April 26th.
Yes.
Okay, so now you're changing your testimony to say she actually wasn't engaged in therapy regularly until a month ago.
2 months ago.
Today is May 28th, Mr.
Oh,
Alford.
then, okay, then, I'm sorry. Yes, a month ago, 26th.
Okay, so her consistency from 2019 until today that you are so impressed with encompasses 4 weeks worth of therapy when you show up at her home to do it?
She's made that much progress in the last month that I've seen her, but in communicating with her about when she started to remain sober, she's been doing really well.
Based on what she tells you.
Yes.
No other questions.
All right, Ms. Merritt,
No questions, Judge.
Ms. Sims,
No questions, Your Honor.
Ms. House.
Yes, Judge, I have questions. Mr. Alford, what you are testifying today is not only based on what Laura Melvin tells you, isn't it also based on your observations?
Yes.
And if you observe something differently than what a client would tell you, would you not represent that to the court honestly?
Yes.
Objection, Your Honor, relevance?
Overruled.
Now, Mr. Alford, you understand the department honors not just showing up for services to check boxes, correct?
Yes.
Have you heard this phrase of a parent just checking boxes from the department throughout your history with them?
Objection, Your Honor, relevance?
Overruled.
I don't know if I've heard the phrase of checking boxes, but another way to say it is going through the motions. And I don't see that from Ms. Melvin.
I'm going to go over where Ms. Melvin is as of today. Has Ms. Melvin identified obstacles hindering her participation? Hindering her participation? Yes or no?
Yes.
Okay.
Yes, she has.
And currently, are there any obstacles hindering her participation?
Not currently, no. No, not currently.
And is she able to incorporate new information into daily living?
Yes.
Can she process new information into daily living?
Most
And I
definitely.
have to object. They're leading and they're totally outside the scope of the recross.
Actually,
Overruled. Go ahead.
thank you. Currently, based on the exhibits provided by the intervener, are there any clinically recommended strategies to aid Ms. Melvin in developing skills to overcome obstacles at this moment?
Are there any clinically recommended skills?
Strategies?
It's really to continue to incorporate all of the principles she's been already incorporating in reference to remaining sober.
Okay. And at this time, when you are assessing her progress, you would state that the client understands treatment and continues to participate, correct?
Yes, correct.
Based on your observation, can she maintain lifestyle changes?
She can maintain them and also improve on them.
Okay. Does she have any lifestyle changes at this moment that need to be improved?
The only one that I see that they're already addressing is to, now that things are opening up, is to get out and connect other people in their circles or to be social, to be social and to connect with other individuals.
Okay. And they are doing that, correct?
They're attempting to look for a place where they can connect with others, and specifically church.
Okay. And Laura Melvin does take ownership of her actions, does she not?
Yes, most definitely.
Does she also take ownership in her part in the precipitating events that led to the current problems being addressed?
Yes.
She displays a high capacity to improve, correct?
She does.
And as far as the home that you have been in, you would find that home appropriate, would you not?
Yes, as from what I've seen, yes. I've only seen the living room, but yes.
At any point in time that you've arrived, has Laura Melvin ever prevented you from seeing her home?
No.
Do you believe from what you've seen that the home is appropriate for a child?
From what I've seen, yes.
No further questions. Pass the witness.
Any other questions for this witness? All right, then maybe he be excused. All right, hearing no opposition, Mr. Alford, you are excused.
All right, thank you.
All right, Ms. Pearsall, any other witnesses?
Just a rebuttal witness, so I rest for now.
Anything from Ms. Sims?
No, Your Honor, no witnesses.
All right, Ms. House, go ahead.
I would like to call Laura De La Garza. Lucinda De La Garza, excuse me.
Okay, hold on. I think with the truth, so help you God.
I do.
Go ahead, Ms. House.
Thank you, Judge. Can you please state your name for the court?
Lucinda De La Garza,
Okay, and how are you employed?
nurse practitioner with a psychiatrist.
Okay, and who is your the psychiatrist you work under?
Raul Capitain.
And how long have
Have
Judge,
I been there?
I'm sorry, I hate to interrupt. I need to take something right fast.
I'm sorry, I got a call.
one moment, Miss De La Garza. We'll wait for the judge to return.
Oh, okay. I didn't hear what he said.
We'll just be on mute until he returns.
Oh, okay.
Okay. Ms. De La Garza, how long have you been a nurse practitioner?
16 years.
And where were you educated?
Texas A&M in Corpus Christi, Texas.
And what degrees have you achieved?
Oh, I'm sorry. I've been one for 17 years. I'm sorry. Well, I got my associate's degree in nursing, bachelor's degree in nursing, master's degree in nursing. And that's all I've ever done, nursing.
And what trainings have you, professional trainings have you received in order to service as a nurse practitioner?
I've trained with a pediatric doctor, a general practice doctor, a gynecologist, and worked with 3 psychiatrists. And I go to a lot of, I have to do a lot of continuing education in psychiatry, and every 2 years, and then and I have to submit 20 continuing education units, and then every 5 years I have to submit 150 continuing education units.
And as of today, you currently can practice as a nurse practitioner, correct?
That's correct.
You do have knowledge of the facts of this case, don't you?
Yes, I do.
And you've created written notes as to your treatment to Laura Melvin?
Objection, Judge. Meeting.
Yes, that's correct.
All right, and is this to getting to trying to admit notes?
No, just admit her as an expert.
All right. Okay.
Unless the party
is anyone objecting to that? Did she?
I was objecting to the form of the question, Judge. I'll waive it.
And
I'd like to admit Miss Lucinda De La Garza, a nurse practitioner, as an expert.
An expert in what?
In her being a nurse practitioner and providing she provides medication management to Laura Melvin for her psychiatric care.
okay, and wasn't she admitted as an expert at the previous hearing?
I think she might have been. I'm not sure, Judge.
All right. I will admit her as an expert.
Yes, I was.
I'll take judicial notice of the previous testimony and admit her as an expert just as a nurse practitioner.
Okay. Ms. Garza, how long have you been working with Laura Melvin?
She, about a year.
Okay. Now, prior to you providing assistance, actually, let me ask you, have you ever met with a Dr. Miller?
What's his first name?
One moment, let me get his name.
Thank you. Because I tell you that I haven't met with him as a psychiatrist, but.
Dr. Jason Miller.
Okay, I have not.
Okay. Has Dr. Jason Miller, psychiatrist, ever contacted your office to express concerns about your treatment?
No, not that I know of.
And outside of yourself, at Dr. Capitane's office, Laura Melvin does not have another psychiatrist, correct?
That's correct.
So you and you at the office of, let me ask you, who would be in the best position to provide insight to the court as to Laura Melvin's medication management when it relates to psychiatric services?
The doctor and myself.
Okay. I'm going to ask you about Laura Melvin's current medication management.
Okay.
When is the last time you have seen Laura Melvin?
5/19/2021.
Okay. And currently, Miss Melvin is on, what medication is Miss Melvin on?
She is on doxepin for depression and hydroxyzine for insomnia, and that's all.
Okay, she's currently on doxepin and
hydroxyzine.
And when did her medications change?
She had been weaning off of them herself from April through May, and then she was able to manage just staying on those 2 meds.
The last time we were here, it was noted that Miss Melvin was taking 100 milligrams of Seroquel. Is that correct?
Yes, but she's no longer on that.
Okay. And why was she taking Seroquel?
It's good for bad depression and anxiety.
Does it treat insomnia?
Yes, it could make, help you fall asleep, but she didn't need it anymore.
And during the last time we were here, Miss Melvin was on Lexapro. Is that correct?
That's correct, but she was not needing that either, and she quit taking it.
Okay. As far as carbamazepine,
that was for nerve pain, and she doesn't need that anymore either.
Okay. And what about methylphenidate?
Yes, that one was the real low dose, and she decided that she didn't need that either.
Okay. Now, as you wean Miss Melvin off of the prescription medications, who's observing her throughout this process? Is it you or Dr. Capitane?
Me.
Okay. And when Laura Melvin was on the Seroquel, hydroxyzine, doxepin, Lexapro, carbamazepine?
Yeah, carbamazepine.
And the other medications, would these knock out Laura Melvin to the point where she would be unable to wake up at night?
Not at all.
Jackson calls for speculation.
Can I answer that or no?
No, the judge needs to rule.
Sorry. Okay, I'll ask Ms. House that you ask the witness about whether she has a professional opinion about the answer to that question.
Ms. De La Garza, do you have a professional opinion as to whether or not the cocktail of medications Laura Melvin was on, even last month, would prevent her from being woken up in the middle of the night?
No, they would not.
And can you explain to the court why that would not be the case?
Because with every medication that is used for insomnia, it's never good enough. You always need two, and even at two, they'll still wake up because they have a bad case. I mean, insomnia is hard to control. It's hard to go to sleep, and then when they do take it, they sleep like normal, like if they're easy to wake up.
And based on the dosage that Laura Melvin was given, would you be surprised if Laura Melvin had a hard time waking up?
Yes, I would.
Opinion?
Yes, I would, because those have no black box warnings. They are not extremely, sedating like the ones that are controlled substances like Restoril or Ambien. But even Restoril or Ambien, those patients still need hydroxyzine to help them sleep. So that's surprising. And even those patients don't, they don't.
Objection, Your Honor, narrative and non-responsive.
I'll overrule the objection. Next question.
As to the current medication Laura Melvin is on, are there any addictive effects?
No, there aren't.
Can you please explain this to the court?
The only ones that could be addictive are the Lexapro and the Xanax, and she had no problems getting off the Xanax. In fact, when I told her no more, she didn't, peep an objection. She just said okay, and I was so proud of her. And then the Lexapro, they're on antidepressants. That is hard to get off of, but she weaned herself off of it, and actually she probably never took it every single day. So and now she doesn't want it anymore.
When was the last time Laura Melvin was prescribed benzodiazepines?
That was several months ago when it was discontinued.
Okay. And you understand that this decision was made as part of her medical team's recommendation?
That's correct.
Okay. And also the court ordered that Laura Melvin be taken off of benzodiazepines. Were you aware of this?
I was not, because I got her after she started having the court hearings, and there was another nurse practitioner that used to, watch over her. But now she's my patient, and the first time I saw her, we both agreed to get off the Xanax.
Sustained.
During the time Laura Melvin was being weaned off of benzodiazepines, would you be surprised to know that she was feeling ill?
I would not be surprised, but she never complained about it. But, people do complain about that a lot, and she did not complain at all. She was able to just stop.
Objection, non-responsive.
I'm sorry. I said sustained.
Okay.
Go ahead.
What is Laura Melvin's current treatment plan moving forward?
She made it clear that she wants to.
Objection, Your Honor, non-responsive. I don't know what she said has anything to do with her treatment plan.
As with all
I'll sustain that, Ms. Rex. I'm going to ask you just to answer the question. If the attorneys want some follow-up about why whatever plan was formulated, why it was formulated, they can ask you follow-up questions. Go ahead, please.
And I'll be more clear. I apologize, Ms. De La Garza. As it relates to medication management, what will be Laura Melvin's treatment plan moving forward that comes from you?
Our plan is always to decrease and discontinue medications, and we'll assess them first. And if they still need it, we continue to prescribe it.
Okay. And and would you find that your assessment of Laura Melvin's weaning off of prescriptive drugs your facility prescribed, would you find that to be appropriate?
Yes, when she first started, it was when she got her baby taken away, but before that, she used to be happy, and then she got real sad, came to us, and now that she has hope, she feels like she doesn't need all that medicine anymore. And I wouldn't be surprised if she quit coming.
Would you prescribe medication to any patient that just asks for it?
Oh no, not until a full assessment would be made.
And would you describe Laura Melvin's interaction with you as being a patient that is just hungry for pills?
Oh, heck no. Mm-mm. She is not.
Would you describe Laura Melvin as having a healthy relationship with medication management as provided by your facility?
She's pleasant. But the patient is the boss at home when they have their medicine, whether they'll take it or not. And then when I ask them questions, they usually tell me the truth. And then that's how I can reduce the medicines. And so she's always been honest as far as I can tell.
Would you describe Laura Melvin's, based on your services to Laura Melvin, would you assess in the past months that she has used prescriptive drugs in a way that was inappropriate?
No, I would not. Mm-mm. And plus, we prescribe her medicine, and we are very careful, and the pharmacists are very careful also. And they have a lot of people watching over them. It's hard to abuse drugs with the Texas monitoring system and the pharmacists. If what they do is they'll call and they'll get it clear.
Well, I think she is responding to my question. She's talking about the monitoring of the abuse of drugs. And Judge, you're muted. Judge, you're muted.
Overrule the objection. I think it's getting on towards narrative, but I'll overrule the objection.
Thank you.
And Ms. De La Garza, how many times have you been contacted by Bobby Garza with allegations that Laura Melvin was addicted to the drugs to the substances you were prescribing Miss Melvin?
Never.
How many times has the attorney for the child contacted you with concerns about the medications that were prescribed to Laura Melvin?
Never.
How many times have you been contacted by CASA with concerns as to the medications prescribed to Laura Melvin?
Never.
How many times have you been contacted by the interveners with concerns as to the medications you prescribed to Laura Melvin?
Never.
Based on your observations of Laura Melvin, in your professional opinion, do you believe she is capable of nurturing a child?
Yes, I do. Speculation.
I'll overrule the objection. Sorry.
Miss De La Garza, you can answer.
Objection, Judge. This witness has been designated as a nurse practitioner for psychiatric reasons. This is not a psychologist or someone who has the background to be able to.
Okay, I'm not taking her testimony as an expert opinion, just as her opinion as someone who knows and deals with.
I don't believe that there's been any foundation, Your Honor, laid that indicates that she can make that kind of assessment or judgment.
I think any rational adult can make that assessment. Go ahead.
And Ms. De La Garza, you can answer.
Yes, I believe that she is capable to raise this child and teach her everything just as any other mother would. With, she does not exhibit inability to have the energy and motivation and love to bring up her daughter properly.
And in your professional opinion, what medications is she currently on would impair her ability to have a successful visit with her child?
None.
Thank you. No further questions. Pass the witness.
Thank you.
Ms. Merritt?
Ms. De La Garza, you indicated that you're a nurse practitioner. Is that correct?
That's correct.
And is it true that you testified that Ms. Melvin herself weaned herself off of several of the medications that she was being given by your office?
That's correct.
And as a nurse practitioner who follows the care of patients, is that a suggested method of handling your medication?
That one is something that is the opinion of depending on the experience. And then, we are always advised from the state to do trial dose reductions. And instead of taking the pills away and then they cry that they took their pills away and they're sad, I tell them, you try it at home, and if you feel good, you let me know, and then I'll DC them next month. And that's what I do, so that my boss doesn't get mad at me and say, why are you taking away the meds?
So,
but we always do trial dose reductions.
So, Ms. De La Garza, you inform and instruct your clients to self-wean them off of psychiatric medications?
Yes.
Isn't it dangerous to have a patient who is on psychiatric medications to be taking themselves off medications without a full oversight?
Absolutely. When they have schizoaffective disorder with bipolar depression, then I will not want any antipsychotic to be discontinued. I would want them to stay on it. But her case, she's not schizoaffective disorder, bipolar. She is just with depression and anxiety. And as you can see, those meds are not likable. And we give them to them as long as they can tolerate them. And then when they don't need them anymore, they can wean themselves off.
I'm sorry, what was the objection?
Narrative.
Overruled.
Miss De La Garza, the medications that Laura Melvin self-weaned herself off of have physical effects to the body, correct?
Well, not only the Xanax, not the ones that she took herself off of.
So there is no medical effects. You're indicating, as a nurse practitioner, there is no physical effects of taking yourself off of multiple psychiatric medications without doctor knowledge. There's absolutely no side effects from that.
As I explained before, the Lexapro and Xanax are addictive, and those were hard to take off.
Okay. All right. I think that your question presupposes things that I didn't hear the witness testify to. I'll let you rephrase it if you will.
Ms. De La Garza, yes or no? Are there any side effects from weaning off of these medications?
No. They're not the kind that you get physically addicted to, like the Xanax. She was already weaned off of that.
Ms. De La Garza, that was not my question, whether or not these medications were addictive substances. My question is when you automatically are taking yourself off of medications, there are effects to your body by stopping those medications, is there not?
That's correct. Yes, that's correct. There is, but that's why she did it herself at home. Slowly, as much time as she needed to.
But she didn't ask you to be weaned off of those, did she?
No, she weaned herself off without letting me know.
In December of 2020, she was prescribed an ADHD medication, wasn't she?
She was, but she did not want that anymore.
When exactly did Miss Melvin decide that she did not want any kind of psychiatric medication at all?
She hasn't decided that yet.
When did she describe to you, Miss De La Garza, she wanted to be getting off of those medications, that she wanted to decrease her medications?
From the first time that I saw her, she told me, and I said we'd work on it. And then I gave her instructions. But I did not take her medicines away. And she did herself.
I understand that, Miss De La Garza. You did not instruct her to stop taking any medications, correct?
Not abruptly, no.
You did not instruct her to wean herself off of these particular medications at all, did you?
Oh, yes, we weaned her off of the Xanax a long time ago. But the rest of the meds,
so you weaned her off of the Xanax, correct?
Yes.
You weaned her off of the benzodiazepines, correct?
Yes.
Between you and Dr. Roberts, correct?
I don't know Dr. Roberts.
Mr. Roberts, excuse me.
Oh, the NP, Mr. Roberts. Yeah, he went extra slow. I went faster.
So, and it was isn't it correct that it was in Miss Melvin's chart that she was to start weaning off of the benzodiazepines as of August of 2020?
I have to look at her chart to see.
Is it fair to say that she was still taking benzodiazepines as of December of 2020?
I have to look at her chart, but as soon as I started to see her, the next month she was off of it.
Objection, unresponsive.
Objection. She did respond. She said she had to look at her chart.
And then she went to a non-responsive section.
Okay. Sustained.
Miss De La Garza, when did Miss Melvin stop using the Adderall?
May of 2021. That's when she
Objection, unresponsive.
Okay, Ms. De La Garza, let me say that sometimes the answer to something is yes, but, or it may be yes, because. And if you're just getting a yes or no question, I'd ask you to just give the yes or no. And if one of the attorneys believes they want to follow up on the but or the because, they'll have an opportunity to do that shortly.
Okay, thank you.
Is it fair to, yes or no, Miss De La Garza, Miss Melvin stopped taking the Lexapro, the nerve pain, the methylene, the Adderall as of May 2021?
Between April and May.
Thank you. I have no further questions.
Ms. Sims?
I have no questions, Your Honor.
Ms. House?
No further questions, Judge.
I have some, Judge.
Go ahead, Ms. Pearson.
Thank you, Judge. Is it true, Ms. De La Garza, that you have never done a drug test on, that you haven't done a drug test on the mother since before coronavirus?
I have to look at her chart.
So the answer is you don't remember?
I don't remember. I'm at home now. I should have brought her chart with me, but.
Okay. Do you recall testifying at a hearing a couple of months ago?
Yes, I remember.
Okay. Do you recall testifying at that hearing that you haven't drug tested her since the coronavirus began?
Objection.
I don't remember, but I believe it.
What's the objection?
Asked and answered.
Question. Thank you, Honor. Ms. De La Garza, what was your answer? Do you recall testifying at that hearing that you haven't drug tested her since before coronavirus?
I don't know.
Are you licensed by the Texas Board of Nursing?
Yes, I am.
Okay. And when did you start working at Dr. Capitan's office?
2012.
Okay. Have you ever been disciplined by the Texas Board of Nursing?
Yes.
Okay. And when was that?
2019.
And what were you disciplined for in 2019?
Poor documentation.
Okay. Were you also disciplined in 2017?
No.
Okay. And you were employed at the same office at the time you were disciplined?
Yes.
And specifically, were you disciplined for exceeding your scope of practice as a family nurse practitioner by treating psychiatric patients, although you're not licensed as a psychiatric mental health practitioner?
I don't have to answer these questions.
Then I've asked that you order her to answer.
Objection relevance.
Judge, she admitted her as an expert in what she's been specifically sanctioned and put on probation for not being allowed to practice. And she's a witness. She has to answer every question asked.
These medicines are not dangerous for her.
Objection, unresponsive. Judge, you're muted. You still muted.
Stella Garza, has there been any procedure such as an expunction that has sealed any of your records?
No, sir.
All right, then you will answer the question.
Ms. De La Garza, were you sanctioned and put on probation for exceeding your scope of practice as a family nurse practitioner by treating psychiatric patients, although you're not licensed as a psychiatric mental health practitioner?
Well, that's their opinion, but yes.
Okay. And how long are you on probation based on that sanction?
Just 2 years.
Okay. When does the 2-year end?
In July 2021.
Okay. And isn't it true that you're violating your probation by continuing to prescribe treating psychiatric patients, which is what you got sanctioned for the first time?
Okay, I'm going to mute you, Ms. De La Garza. I don't know for a fact, but I would suspect that maybe the attorneys know that it's a criminal offense, well, I don't know, to prescribe medication that you're not allowed to prescribe. Let me ask the attorneys. I don't know why, maybe not. I don't know why the pharmacy would honor it if she wasn't able to prescribe it. I just want to make sure whether I have a Fifth Amendment. Okay, man, you're still muted and you're going to remain muted. So let me ask the attorneys, are you aware of any possible criminal responsibility for exceeding the scope of what you can prescribe?
Judge, I don't know, but maybe we should err on the side of caution. And, you know,
I will do so. So Ms. De La Garza, let me tell you that I don't know for a fact, but there may be some potential criminal liability in the response to the question you were just asked. I need to tell you a couple of things. The first is that under the Fifth Amendment to the United States Constitution and under the Texas Constitution, you have the absolute right to refuse to answer any questions that might tend to incriminate you. However, you must either assert that right or you must waive it. By that, I mean you can't answer a few questions that might tend to incriminate you and then decide that you don't want to answer anymore. The other thing I have to tell you is that you're not a participant in this case, so you're not a participant in this case, so it will not be held against you personally one way or another, but I could weigh that in the balance whenever I consider the weight and credibility of your evidence. The last thing I can tell you is that you have the right to consult with an attorney about whether you might possibly be putting yourself open to criminal liability by answering this question. So my question for you is, are you prepared right now to waive your Fifth Amendment rights against self-incrimination, or would you prefer not to do so unless and until you've at least had a chance to consult with an attorney? And I will unmute you. Or ask you to unmute yourself.
I prefer to plead my Fifth Amendment until I consult an attorney.
Judge, and I would ask that you draw a negative inference from that.
We'll consider that request. Your next question.
Based on the terms of your probation and suspension, you were ordered to surrender all your United States Drug Enforcement Administration controlled substance registration certificates. Is that correct?
Okay, and I'm
not asking for anything.
I understand, but I'm going to take that question as being within the same scope of her Fifth Amendment assertion, and I'll let you get that on the record, but I'm not going to require her to answer that.
Ms. Delgarza, you're muted.
Okay, your next question, Ms. Pearsall.
Judge, I would just ask that you draw a negative inference from that, please.
Well, and I don't think he can if he's instructing her not to answer. And so,
well, I'm instructing her that I take that under the. Okay, well, Ms. Pearsall, I'll let you ask any other, tell me what any other questions you might have are that would come under the Fifth Amendment protection. But I think that you're not allowed to keep asking the witness the additional questions.
Well, Judge, and just to be clear, I'm not asking for anything Chezo hasn't done. I'm asking what she was ordered to do. I'm not asking what Chezo hasn't done. I'm asking if that was part of her order.
But again, if she has given prescriptions since the day she was put on probation, then I still think she comes under it. It doesn't have to be, did you do it? It's anything that might tend to incriminate you. So I'll take that it's still under the Fifth Amendment.
Okay. So my next question, Ms. Delgarza, is, were you also ordered by the Texas Board of Nursing to surrender your Texas Department of Public Safety Controlled Substance Registration Certificate and any other government issued certificate authorization to prescribe controlled substances?
And I'll take that under the same Fifth Amendment. Go ahead, Ms. Pearsall.
And additionally, were you ordered to cease and desist from exceeding your board authorized scope of practice as a family nurse practitioner and ordered not to manage medical aspects of care of psychiatric patients until such time, if ever, you are reinstituted?
I'm going to object to compound question.
Right. I'll take it that that's still under the Fifth Amendment.
Okay. And again, I'm just asking that you draw a negative inference from that, and I have no further questions.
Any other questions for this witness?
Actually,
first, let me ask Ms. Pearsall, just as an officer of the court, and you're representing the whatever webpage or something you've gone to, that does not show that it was a suspended or probated suspension, but active. I don't know if nurses are the same as attorneys.
Let me read it, Judge.
And I'm going to object to hearsay.
It shows that it was suspended, that her license was suspended and she was put on probation, exactly like she testified, and that the term is no controlled substance prescribing.
I haven't seen this, Judge. I'm going to object to hearsay. I don't know what she's talking about.
I was answering the court's question.
I asked the question. I understand that Ms. Pearsall wasn't personally involved. I'll overrule that objection. Any questions, more questions for this witness?
No questions.
No questions.
Ms. Merritt?
Nothing, Judge.
All right, so may she be excused?
Yes, Your Honor.
Okay, Ms. De La Garza, you are excused. All right. Is there anyone left other than Ms. Melvin?
No.
Only if we have, depending on if we need a rebuttal witness or not, Judge.
All right, we're going to take a 10-minute break so I can check with my son, and then I'll come back.
Thank you, Judge.
Go ahead, Ms. House.
Thank you. I'd like to call Laura Melvin.
Okay.
And how many children do you have?
I have 5.
And where does Lexi fall in the 5 children that you have?
She's the baby. She's the youngest.
And are there any plans to have children beyond Lexi?
No, ma'am.
And I want to ask you about services that you have been engaged in, Ms. Melvin. As of today, how long have you been sober of alcohol?
My sobriety date was September 13 of 19.
Okay. And okay. Currently, oh wait. Since that time, you have submitted to drug tests to the department, correct?
Yes, ma'am.
When has the last time you have submitted a positive alcohol or drug test to the department?
I have not. They've all been negative.
When is the last time since we've been to court that the department has asked you to submit to a drug and alcohol test?
Since April, is that what you're asking?
Yes. Well, since this hearing, we've been in this hearing rather.
Oh, they have not.
Okay.
They've not asked me to submit.
So there's no recent results that the court is not aware of as of today?
No.
You have not recently consulted or seen Dr. Miller, correct?
Correct.
And when you, I'm going to ask you about what we just heard about in court. Were you aware of any status issues as it relates to Lucinda De La Garza's ability to provide services to you?
Not at all. I had never heard that information.
What was your reaction to the information provided by Alana Pearsall?
Objection? Relevance?
Okay, ma'am, let the objection come in. Yes, what's the objection?
Relevance?
Is it the relevance to the information provided to this case? I'm confused.
Is it relevant whether or not she was surprised? I don't think that really matters, and I don't think that it goes to the issue at hand. And it's 4:56.
I think it matters, Judge, as it relates to my client's who she's receiving services to, and what she knows.
I'll have a question on that basis.
So, Ms. Melvin, what was your reaction?
I was shocked. I had no idea.
Were you told by Dr. Capitaine any of the information that came out in court today?
No, ma'am.
Were you told by Lucinda De La Garza any of the information that was provided in court today?
No, ma'am.
If that information would have been provided to you, what would you have done?
I would have found a new provider.
You heard Dr. Miller's testimony as it relates to the medication you were on the last day we were in court for this hearing, correct?
Yes.
Okay. And you heard him state that he had no problems with the medications that you were on, correct?
Yes, ma'am.
Now, who was giving you pressure to wean off of the medications that you were on?
The court.
And when you say the court, it wouldn't have been Judge Wilson, correct?
No, ma'am. It would have, sorry.
Okay, which court are you referring to?
I can't pronounce her last name. Judge, it starts with a D. Oh, no.
Would this be the court for CPS?
Girolami?
Yes.
Judge DeGirolami?
Yes, that's it. I'm so sorry.
Okay. And what did you do in order to satisfy the requirements from the court, Ms. Melvin, when it came to medication management?
I slowly weaned myself off so that I would be off of all of it, and successfully have done that.
And when you say wean yourself off, are you speaking of the benzodiazepines?
Well, yes, along all of them, really. I'd like to be unmedicated.
And while you like to be unmedicated, do the medications you're currently on interfere with your ability to parent?
No, not at all.
And in fact, while you were on the cocktail, that the concoction of, well, I should say the group of medications Dr. Miller testified to, were you parenting?
Yes.
Who were you parenting?
My 4 boys.
And what type of contact do you have with your 4 boys?
I have unsupervised visitation. We have joint custody.
And when is the last time you have visited with your any of your other biological children?
It would have been Wednesday of this week.
And can you describe to the court the extent what that visitation looked like?
Well, that particular visit was they came over for dinner. So my son is graduating this year, and so he had a request for dinner, and they came in and we ate.
Who cooked dinner? Okay.
Oh,
I'm sorry. Who cooked dinner?
I did.
And what did you prepare, ma'am?
We had fried catfish, French fries, corn on the cob.
And how were you able to secure food or groceries for this dinner?
Went grocery shopping with my husband.
All right. And so you're able to provide for your children?
Absolutely.
And how often do your sons ask about Lexi, ma'am?
Very often. Regularly.
And what is the goal of today's hearing that you're asking the court to do as far as your access to Lexi?
Reinstate visits and would like for them to be more frequent.
Okay. How frequently are you requesting the court to have visitation with Lexi?
I'd like weekly.
And as far as supervisors with Lexi, what concerns do you have, if any, about Judy Dickey continuing to supervise your visitation with Lexi?
I am concerned about that. I'm concerned about her, in her testimony, her repeating so much of what she heard from foster mother and not gaining information on her own. She seemed to just be repeating everything that she's been told by CPS or foster parents.
And do you believe this representation interferes with your ability to reunify with Lexi?
Yes, I do.
Would you be in support of having an unbiased third party supervise your visits with Lexi with costs borne by the department?
That would be fine. I'd like unsupervised, but if it has to be supervised, then I would like for it to be by an unbiased party.
I want to ask about the unsupervised visits. Now, the unsupervised visits that you have, who generally accompanies you on your unsupervised visits with the siblings, with the sibling group that you currently have access to?
If anyone, it's my husband.
Okay. And how would you describe that relationship?
Positive. It's really good. I think they look up to Mac, and he has been stable and a very good positive influence on them.
Do you believe that the Texas Department of Family and Protective Services has provided reasonable accommodations for you in order to reunify with Lexi?
No, I don't.
And well, let's talk about that. There were concerns posed about your understanding as to fetal alcohol syndrome. Do you recall?
I do.
As of today, how many follow-up sessions have you had with a doctor to find out more information about Lexi's fetal alcohol syndrome diagnosis?
None.
How many times has Bobby Garza contacted you to let you know that a meeting is pending?
She has not.
How many times has a caseworker, Bobby Garza, contacted you to let you know that a meeting is coming up in the future?
She has not.
Asked and answered. You're muted.
What kind of meetings are we talking about?
These are the meetings for the diagnosis of fetal alcohol syndrome.
And I'll overrule the objection.
And Ms. Melvin, You heard Bobby Garza testify that a second meeting was necessary because it was even hard for her to understand the information provided from that doctor. Did you not?
That's correct.
Did you not also hear Bobby Garza testify that it was necessary? Well,
Objection, Judge, leading.
Sustained.
as it relates to Lexi's medical genetic diagnosis, genetic syndrome, how many meetings has the department provided for you to attend when it comes to a geneticist?
None, I don't believe. We had one meeting, but it wasn't with the actual doctor.
And how many times you heard, to follow up on Bobby Garza's testimony, would you be willing to meet with a geneticist if the department would just make the appointment?
Absolutely.
As of today, has the department bothered to make an appointment between you and a geneticist?
No.
Objection, Judge. Argumentative.
Sustained. Sorry.
I'm going to ask you now, as it relates to Ms. Melvin, when you were weaning, can you describe to the court how you weaned yourself off of some of the medications you were prescribed by your psychiatrist?
Well, it's really easy. What I would do is just start one at a time, taking a half a dose, and then, seeing what effects that would have, and then, going down. And I only did one medication at a time so that I'd know what reactions were happening from which medication.
And who instructed you to wean yourself off at home?
Well, I don't know that I was necessarily instructed, but it was Dr. Miller that said that it needed to happen, and then the courts agreed and said that I needed to come off of them.
And who prescribed you your medication, Laura?
Dr. Capitine.
Okay. And what was your understanding as to who was responsible for the medications and the medication dosages that you were on?
Ultimately, it's Dr. Capitine. He oversees all the treatment.
How many times has Dr. Miller contacted you with concerns about your medication management?
He has not.
How many times has it been hard to wake you up at night when you're sleeping?
Never.
What concerns do you have, if any, about the medications that you are on?
I'm not concerned right now. I think I'm on a good dosage.
In what ways have the medications that you are on interfered with your ability to parent?
Well, that I'm on now?
Yes.
I don't think they interfere at all.
As it relates to, let me ask you, what services are you currently engaged in right now?
Therapy with Mr. Alfred, and also therapy with Dr. Castillo.
What else are you doing?
And then, of course, attending AA meetings regularly.
How regularly do you attend AA meetings?
3 times a week.
Okay. And where do you attend those meetings at?
There are virtual meetings through aa.org.
And what step are you on the 12-step process?
Well, 12 right now. Of course, you kind of have, I revisit the other steps regularly. I think that's a healthy way to maintain my sobriety, because you always need to be in review of your place and in review of how you're living, but still looking for that spiritual reckoning.
Okay. And what is the step 12?
Step 12 is to receive a spiritual awakeness.
Okay.
And I've been talking with Mr. Alfred about it a lot. I think I
Objection,
didn't understand it.
non-responsive.
Okay. Sustained.
What are you learning in your sessions with Mr. Alford?
Learning how to dig deeper and understand the steps and recovery and sobriety more fully.
And would you describe this process ongoing even past this case?
Oh yeah, I believe so.
And who from the department has taken the time to ask you what you have learned?
Objection, Judge. Argumentative.
Sustained.
Who from the department has asked you about what you've learned?
No one. No one.
With Mr. Alfred.
No one has talked to me at all.
How many times has Bobby Garza asked you what you've learned from therapy with Dr. Castillo?
She has not.
How many times has the department asked you what you've learned from your engagement with NAAA?
I've never been asked.
When is the last time the Bobby Garza has expressed to you concerns about the medications you were on?
The only time that I ever remember her saying anything would have been when she attended a doctor's appointment with me.
Okay.
And
when
she
was that?
was more, oh, I'm sorry.
Sorry.
When would that have been?
Over a year ago, I believe.
Okay. Has Bobby Garza recently attended any type of medical appointments with you?
No.
Has she asked you to attend any medical appointments with you?
She has not.
Has the department reached out to you with any concerns about the psychiatric facility that you were seeing?
No.
Did Dr. Miller take the time to reach out to you with any concerns about the psychiatric facility that was providing services to you?
Action, Judge.
I'm sorry.
Hey.
Argumentative.
I'll allow the question.
Take the time that Dr. Miller takes.
I didn't say take the time. I said
Okay,
did Dr.
I
Miller.
understand that the attorney is posing the questions in a way that advocates a certain position. I'll overrule the objection.
Did Dr. Miller reach out to you with any concerns about the psychiatric facility that was providing services to you?
He did not.
Did Bobby Garza express to you concerns about the last hair follicle that you took for the department?
No, she did not.
Did Bobby Garza provide you with the results of the hair follicle you took?
No, she did not.
Are you concerned that as of today, you have not received those results, ma'am?
Well, I would like to get the official results, but I know what they are.
What do you believe those results to be?
They're going to be
Objection,
negative.
calls for speculation.
Okay, overruled.
You can answer, Laura.
They're going to be negative.
No further questions. Actually, Laura, is there anything else before I pass you? Is there anything else that you would like the court to know?
Just that, a lot has changed. I've learned a lot. I've had a lot of different experiences recently, and I very much think that Lexi and I both deserve to be acquainted and have our visits reinstated to further our mother-daughter bond.
And the house that you live in, I want to follow up with you. Bobby Garza, I believe Bobby Garza stated that you had a mortgage on it. Can you describe to the court the stability of your home?
I do not have a mortgage. It's paid for.
And currently, how is your husband employed?
He's a corrections officer for the state.
Thank you. No further questions. Pass the witness.
Thank you.
Ms. Merritt,
Yes, Judge, can I have one quick minute, please?
go ahead.
Thank you. Miss Melvin, I'd like to ask you several questions. The first question that I would like to ask you is if you have been clean since, you've been clean since September of 2019, correct?
Correct.
And you indicated that you have been sober since September of that time, correct?
Yes.
So you have not attended a drug test in February of 2020, right?
I don't recall specifically.
For a nail test? You didn't show up?
No, that's incorrect. I did show up, but they
you
looked
didn't
at my
test.
nails and
Objection, Judge. The witness is not allowed to finish her answer.
She's
Judge,
being non-responsive.
She's
Okay.
answering the question.
I'll sustain the objection.
Can she finish, Judge?
I would
Yes.
like to ask another question, Judge. I'll rephrase.
She's
And
already.
then Ms. House, you'll have a chance to follow up. Go ahead, Ms. Mary.
Miss Melvin, you attended the nail test on February 26, 2020, correct?
I believe that was when I did attend and was told.
Yes or no? Did you attended on February 26, 2020, a nail test?
I believe I did.
But you didn't actually have a sample taken, right?
Correct.
Okay. And you were sent again in March of 2020 and you didn't show up, right?
That was when I talked. I'm sorry?
All right, Ms.
I'm
Okay,
sorry,
no,
Judge.
I'm speaking. All right. Ms. Melvin, as you've heard me say to many other witnesses, sometimes the answer is yes, but, or yes, and if Ms. House thinks she needs to follow up, she will do so. Please answer the question.
Yes, sir.
And Judge, may I ask, respectfully, if the counsel does not first say yes or no, a witness is just going to answer. You generally what Ms. Merritt is doing is Ms. Melvin starts to answer and then Ms. Merritt says yes or no. If she knows beforehand, it would give my client guidance as to how she would answer or how she should answer that question rather.
Okay, I'll ask the attorneys to be careful with what they're asking. Go ahead.
Duly noted, Judge. Yes or no, Ms. Melvin, you did not attend a drug test on March 17th, 2020.
I believe that is correct.
Yes or no, you did not attend a drug test on April 15th, 2020.
I really don't have any idea on the dates.
Ms. Melvin, you did not take, yes or no, you did not take a drug test in May of 2020?
I don't believe that's true.
In June of 2020, you were asked to do a nail test and you did not test for your nails. Is that correct?
Correct.
In October of 2020, you did not attend a drug test.
I couldn't tell you.
On October 27th, 2020, you did not attend a drug test.
I don't know.
In December 14th, 2020, you did not show up for another nail test to take the nail test.
I don't believe that.
On January 25th, 2021, you were
Okay,
asked.
I want to interrupt just so I'm clear. Ms. Melvin, what do you mean you don't believe that?
I can't remember dates. So for me to say affirmatively, that was the date, I can't do that. But there was only one time that I was asked to take a nail test that I didn't actually go to the facility, and it was because when I called them to schedule the appointment.
So are you saying, when you're saying you don't believe that, are you saying that?
That's a no.
That so is it, so by that no, do you mean that there was a drug test scheduled that you were aware of and you showed up for it? Or are you saying that you're not aware that there was a drug test scheduled? Or something else?
For that particular question, I was mostly concerned about the date because I wasn't sure when it was that I was sent for that nail test. So I don't believe that I missed an appointment. I think, but I couldn't say for sure on that day. Does that make sense?
Judge, I believe that I can clarify for the court because my client's not been given the opportunity to answer questions. She's restricted to yes or no. I believe I can clarify this.
Objection,
Okay,
Judge.
I'll just, so let me just ask Ms. Melvin, how many times is it your testimony, whatever date, how many times has it occurred that there was a drug test of any type that you were supposed to take from the department had requested that you failed to show up?
That I just didn't show up? Very, very few. There was always, if I did miss, there was a reason, and I gave that reason in a timely manner.
All right, go ahead, Ms. Merritt.
It's true that you have not provided a nail sample as of today.
That's true.
And that, isn't it fair to say that Bobby Garza generally sends you for a drug test monthly, at least monthly?
Usually.
You were a signatory to the mediated settlement agreement, is that correct?
Correct.
And is it not true that that mediated settlement agreement that you agreed to included submitting to random alcohol and drug testing? Is that correct?
That's correct. That's correct.
So by not submitting to the nail test, isn't it correct that you're not in compliance with the mediated settlement agreement?
I did show up for it, but it could not be taken. That wasn't my call.
But you did not provide a sample, correct?
I couldn't. And it was the call of the professionals at that office.
You've missed quite a few. Is it fair to say that you've missed a lot of counseling sessions and such throughout the last year, Ms. Melvin?
I don't know that that's completely fair.
So you believe that 4 weeks approximately of continuous counseling with Mr. Alford is enough to alleviate the fact that you haven't been participatory in the 3 years that you've had this case?
That's not true.
Representation.
Okay. I'm sorry, was there an objection?
Yes, that's a misrepresentation of the facts.
Uh-huh.
Judge can determine that, Judge. You can
Okay,
answer for
I'll I'll sustain the objection. I'll ask you to just rephrase it.
Do you believe that your child has fetal alcohol syndrome?
I accept that diagnosis, and what I believe is not relevant, but I accept it, and I'm willing to work with her and work with the professionals and get her whatever treatment they find necessary.
Let me ask you, Ms. Melvin. Ms. House asked you quite a few questions about your dosaging and your weaning off of medication. My question to you is, you're not a doctor, are you?
No, ma'am.
And you have other medical issues other than having depression and anxiety. Isn't that true?
I do.
And considering that I believe you have testified in the past that you have blood pressure issues and stomach issues, do you really think that it was a good idea to wean yourself off of psychiatric medications without the direction of any physician?
I did it very successfully with the request of the court to wean off.
So your answer is yes, you thought it was a great idea?
I think I was successful.
Judge, may I object to, I'm not objecting to your question to the intervener eating in a court proceeding.
Right. Ms. Hicks, let me ask you not to eat while we're in court. Go ahead, ma'am.
I have no more questions for Ms. Melvin at this time, Judge. I reserve the right to recall.
All right, Ms. Pearsall.
Thank you, Anna. How long has your husband had his current job?
24 years.
And how much does he make?
Objection relevant.
Okay, Ms. Pearsall, what's the relevance of this?
Judge, the motions on file for testing requests that Ms. Melvin be ordered to pay for the drug tests, for the patch and the monitoring. So
And
I'll sustain the objection.
You've previously admitted that you have an addictive personality, correct?
I did say that.
Okay. You've also previously admitted that you're an alcoholic?
Yes.
And you've previously admitted that you've been addicted to hydrocodone?
Many years ago.
Is that a yes?
Yes, many years ago.
Okay. And you've also previously admitted that you've been addicted to benzos. Is that correct?
No, I've been prescribed them and taking them appropriately.
So you don't believe you've ever had an addiction to benzos?
No, it was just the hydrocodone.
So you think Dr. Miller was completely wrong when in his professional opinion, he thought you were addicted to them?
I'm not going to say that he
Objection, facts not in evidence.
Ms. Pearsall?
Judge, you've heard Dr. Miller's testimony and you've reviewed, I think, I don't know, his testimony from the de novo, from the record that was admitted into evidence.
Those facts are not in evidence. He was here. He provided testimony, not as to that, from my recollection.
I will sustain the objection. I understand that there's a dispute about their...
Who did you meet with to discuss your daughter's diagnosis?
That was, I have her name written down. I don't recall it right off.
Okay. Do you recall what kind of doctor that was?
She was a technician of some sort, or a nurse, or she wasn't the doctor.
Okay, what sort? What was her specialty?
I believe that she was the geneticist.
Okay, so you met with a geneticist, correct?
Objection asked and answered. That's a misstatement of what my client has stated. She said she met with a technician or a nurse.
And then she said it was a geneticist. I'm trying to clarify.
Overrule the objection.
Okay, Ms. Melvin, I'm just trying to understand what you said. So the person you met with was a geneticist, is that correct?
I believe it was somebody in the office for the geneticist. I don't believe it was her because...
So you think it was like a nurse practitioner in the geneticist office? Is that what you believe?
That is the understanding that I had.
Okay. And how long was that meeting?
Probably 30, 40 minutes.
And what was explained to you during that meeting?
Well, they touched on the diagnosis, but you know, like it's been stated before, it's a lot of information to take. And that's why a secondary meeting was supposed to take place with the actual doctor.
Ms. Melvin, that wasn't my question. My question was, what did you learn during that meeting?
Oh, well, I learned what the diagnosis was and some of the effects that could be and that could happen, and how they came to that diagnosis.
Okay. So what is your daughter's diagnosis?
The fetal alcohol syndrome, and then the genetic disorder.
Okay. What is the name of her genetic disorder?
I couldn't tell you.
Why not?
I've asked for that information several times since that meeting because I didn't write it down at the time, and I've not been provided with it.
So you don't know what it is because you didn't write it down during the meeting. Is that correct?
I was not given it when I requested it.
The genetic disorder was discussed during that meeting, correct?
Yes, it was.
Okay. So you were given the name of it during that meeting.
Ms. Pearsall, I'm going to ask you to move on.
Okay. What caused your daughter's fetal alcohol syndrome?
Objection relevant.
Overruled.
Objection speculation. She's not the one that created the diagnosis.
Well, actually, she's the one that caused it.
Okay.
Objection, facts not in evidence.
Overruled.
Ms. Melvin, answer the question. What caused your daughter's fetal alcohol syndrome?
What caused it? Well, typically it's a parent having alcohol during pregnancy.
And do you acknowledge that you drank while pregnant with Lexi?
I did not.
Okay. So sitting here today, you still denying that you caused your daughter's fetal alcohol syndrome?
Ma'am, what I'm telling you today is that I am willing to work with whatever.
Objection, non-responsive.
Sustained.
Answer the question, Ms. Melvin. Do you take responsibility for causing your daughter's fetal alcohol syndrome, or do you not?
Objection, Judge. We've not had any professional testify that Miss Melvin caused how the fetal alcohol syndrome, when it was diagnosed, how it was caused, or any information as to, that points to Laura Melvin. And so we're assuming.
I'm asking.
Okay, I will overrule all of those objections.
Ms. Melvin, for the third time, answer the question.
I did not drink while I was pregnant.
Okay. And when you testified earlier today, when Ms. Merritt asked you about her diagnosis, you said, and I wrote it down, I accept the diagnosis. You still don't believe that to be a true diagnosis, do you?
Please don't put words in my mouth. And I said I accepted the diagnosis. I do, and I will work with whatever professionals are needed to get her the treatment that she needs to have.
Ms. Melvin, do you recall testifying in December of 2020?
Yes.
Okay. And Your Honor, I'm sharing a portion of this transcript that was previously admitted into evidence. And Ms. Melvin, this was your testimony. The judge asked, I have a question of my own because I want to know, Ms. Melvin, your response to your daughter's fetal alcohol syndrome.
I'm going to object to reading of the transcript. Is there a question?
If you don't interrupt, I'll get there. Your answer was, that is absolutely false.
I have an objection.
Myself, all the screens being shared, I was slid off to the side. Where was I? Okay, I will overrule Ms. House's objection, and I will instruct both the attorneys, address yourselves to me and not to each other.
Yes, Your Honor. Ms. Melvin, did I read your response correctly?
I didn't hear you.
Okay, well, let me read it again. And you can follow along. The judge asked, Ms. Melvin, your response to your daughter's fetal alcohol syndrome diagnosis. You answered, that is absolutely false. Did I read that correctly?
That's correct.
Okay, and I just want to clarify. You testified you had 4 other children, correct?
I do.
Okay. In fact, they're not all of them are children. Isn't that true? Some of them are adults.
Objection. That's adults are still her children. I think that's a misrepresentation.
Understand that some of them are adult children. What's your question, Ms. Pearsall?
How many of them are adults?
1.
Okay. What's his name?
Objection
Robert.
Objection relevant.
She opened the door by asking her about the children. I have a right to
I'll
do it.
rule the objection.
And Judge, by the same token, we weren't allowed to ask the names of the Hicks children. Alana Pearsall objected to that. And so, if it's good for the goose, it's good for the gander. It shouldn't be permitted when it comes to the names of the children that are not involved in this case.
Okay, Hicks information is protected by federal law. There is nothing protected about Miss Melvin's children.
It's also
I'll overrule the objection.
And I'm going to object to relevance. The name of the child is not relevant.
I'll give Miss Pearsall, I don't know where she's going. I'll give her some time to get there before I decide whether it's relevant.
What is the name of your one adult child?
Robert.
So you other 3 children, not counting Alexia, all under 18, correct?
I have an 18-year-old who is graduating high school right now, so I still consider him a child.
Okay. So in fact, your 18-year-old is also an adult?
I guess he would.
Objection. She doesn't have the legal.
Ms. Pearsall, where are we going with this?
Judge, I'll get there in a couple of questions.
All right. I don't need Ms. Melvin's opinion about whether or not an 18-year-old is a child, unless you're trying to suggest that the 18-year-old is somehow disabled.
I'm just trying to figure out which child she's talking about, Judge. So what is that child's name?
Matthew.
Matthew. Okay. And when you said you have joint custody and you have unsupervised visitation, so which children do you have unsupervised visitation with?
The 3 boys. Matthew is still on that court paper. So.
Okay, Matthew and who else?
My younger 2 boys.
What are their names?
Objection relevant.
I thought.
Objection relevant.
Overruled. We've got 2 more questions, Ms. Pearsall, and then I'll sustain that.
What are their names, Ms. Melvin?
Corbett and Holden.
And when you told the court that you had dinner with your children, with whom you have unsupervised visitation this week, which children did you have dinner with?
The boys.
Which boys?
The youngest. Mathis.
Who else?
That was it this week.
Okay. So just Mathis, not the boys, just one. Correct?
Yes.
Okay. How many visits have you had with Corbin, let's say in the last 2 years?
I couldn't tell you how many. I'd have to count.
Approximately.
I have very regular visits with them.
Okay. How many visits have you had with Holden for the past 2 years?
It would be the same.
Okay. Too many to count?
I don't want to throw out a number and be wrong.
Okay. And how often do you typically visit with each child? With Corbin and Holden?
How often?
How long? How long is your typical visit with Corbin and Holden?
Oh, it just varies. It depends on what's going on.
So do they come over and spend weekends at your house? Do they spend summers at your house? What's a typical visitation look like?
It would be weekends, and then in the summer, I have the option to have them either for a solid month or every 2 weeks to 1 week without.
And so have you been regularly exercising your weekend visitation and your 30 days in the summer with Corbin and Holden for the last 2 years?
Objection, compound question.
Sustained.
Sure, I'll break it up. Have you been regularly exercising your unsupervised weekend visits with Corbin and Holden for the last 2 years?
As much as I possibly can. I have issues with my ex-husband, and so it's been strained.
Ms. Melvin, that wasn't my question. My question was, have you not been exercising unsupervised weekend visits with Corbin and Holden for the last 2 years?
Objection asked and answered.
It wasn't answered.
Overruled.
Answer the question, Ms. Melvin.
I make every attempt to have them every single visitation time.
That was my question, Ms. Melvin. My question was, have you not had them for the weekends over the last 2 years?
I have on occasion. Usually it's just for the day.
Okay. And that's unsupervised at your home?
Anywhere I'd like it to be.
Okay. And have you had the kids for 30 days, let's say last summer?
No, I didn't choose the 30-day option.
Okay, did you have them for 30 days at any point during the last summer altogether?
Altogether, yes.
Now the questions.
Okay, where'd she go? All right, Ms. Sims?
Thank you, Your Honor. Miss Melvin, why were your visits with Lexi so sporadic?
There were various reasons. Some were canceled by Miss Garza, and some were because of illness.
Do you understand that your sporadic visitation with Lexi has a negative effect on her?
I understand that she needs consistency. Yes.
Would you agree with me that you have not been consistent in your visits with her through this entire case?
I have as much as I could.
Do you take responsibility for the fact that you've missed so many visits with your daughter?
I take responsibility for the ones that were my fault.
Do you feel that if the judge were to reinstate your visits, you would be able to exercise them consistently without any absences?
Yes, I do.
What is different now than for the rest of the history of this case?
There are a lot of things. I've been through a lot of therapy. My medications, of course, have changed. I'm feeling great now that we have everything regulated better, and I'm ready to show that I am consistent with her visits.
Do you understand that there are still some concerns for your interaction with your daughter?
I have heard some concerns expressed.
Do you agree that it would be helpful for you to continue therapeutic visits to work on your relationship?
I would not be opposed to that as long as it was with somebody other than Miss Dickey.
What is your reaction to the fact that your daughter has not expressed a desire to have visits with you?
I don't believe that's true.
So can I ask you, for your compliance with services, it's also been similarly sporadic through the life of the case, correct?
Not through the life of the case.
Okay, can we say in recent history from the time period we're discussing with this hearing, November of 2019 until March of 2021, your participation in services has been sporadic. Would you agree?
Well, there were a lot of things going on during that time. And so it interfered.
Okay, so let me ask you again, a yes or no answer. I just want to make sure I understand. Would you agree that during the period from November of 2019 till March of 2021, your participation in services has been sporadic?
Yes.
Yes or no? Okay. So you are telling the court now that you believe you can be consistent? Is that correct?
That's correct.
And what do you believe has changed that will allow your participation in services to now be consistent?
Like I said, I've been through a lot of therapy. I've had a chance to regulate my medications, and we're no longer fighting COVID, which interfered quite a bit. So there's a lot of things that have changed.
And when you say you've engaged in a lot of therapy, that is since March of 2021?
Since March, yes, I have. And previous to that, I did as well.
But your previous participation was very sporadic.
No, when I was meeting with Ashley Martin for therapy, I didn't miss.
Thank you. I'll pass the witness.
Okay, Ms. House.
Thank you, Judge. Laura Melvin, thank you for mentioning that. The therapy that you are engaging in with Mr. Alfred, he's not the first therapist to provide therapy for you. Is that not correct?
Correct.
And Ashley Martin, is that there? You heard Ashley, Dr. Miller provide information that he believed the therapeutic services provided by Ashley Martin were appropriate. Did you hear this?
Yes, ma'am.
And were you successfully discharged from therapeutic services with Ashley Martin?
Yes, ma'am.
And would it best be described follow-up therapeutic sessions as it relates to Mr. Alfred?
Yes.
And as it relates to sporadic visitation, you referenced COVID. Can you explain to the court how your family was personally affected by the coronavirus pandemic?
Yes. My husband tested positive, and so we were quarantined to the house for over 3 months. I experienced all the same symptoms, but I tested negative. But because we live in the same house, we had to be quarantined together.
And who told you you had to be quarantined even though you were testing negative and your husband was testing positive?
My physician.
During this time, did you experience COVID-like symptoms?
Yes, I did.
What COVID-like symptoms did you experience during this period?
A lot of flu-like symptoms, fever, chills.
Can you hear me, Ms. Melvin?
I'm sorry? I'm sorry?
I don't know if it, I'm sorry. I'm reading, it says internet connection unstable. My apologies. I think the judge is frozen. Do y'all see the judge frozen?
I'm not frozen. I'm just trying not to sneeze without taking the monitor off.
And Judge, I believe it's my internet connection that's unstable.
Go ahead.
Okay, thank you, Judge. I'm sorry, Laura. Can you explain to the court what COVID-like symptoms you were experiencing during this time?
It was fever, chills, coughing, a horrible sore throat. I lost my voice a couple of times due to the soreness in my throat.
And this occurred in the summer of 2020, around the summertime, correct?
Yes.
And would this have resulted in missed visits?
Yes.
Did you feel it was appropriate to show up to visits with COVID-like symptoms?
No, of course not.
And during this time, weaned off of benzodiazepines, correct?
Okay, hold on. Someone has just checked in. Who is this?
Judge, this is my rebuttal witness. If you can put him in the waiting room for a few minutes till we finish.
All right, did you get that, sir? I'm going to put you in the waiting room. We'll admit you shortly. Go ahead, ma'am.
Ms. Melvin, did you recognize the voice that you just heard?
I didn't hear a voice.
Okay. What is the relationship? Miss Pearsall asked you about visitation with your minor children, correct?
Mm-hmm.
And while you have court orders providing you overnights and summers, who prevents you from exercising this visitation?
My ex-husband.
Why have you not gone to court to enforce denied visitation by your ex-husband?
Because I didn't have an attorney. I tried to do it on my own. I didn't really know what I was doing. But it's because I didn't have representation.
Okay. And when Ms. Pearsall asked you about exercising visits, have there been times you've shown up to exercise visitation when the children were not where they were supposed to be?
Many, many times.
So when you're asked about your failure to exercise visitation, is it accurate to describe it as your volitional failure to do something?
No, I don't believe so. I don't believe that I was at fault. I believe that it's my ex-husband's doing.
Okay. And as of today, would your ex-husband say anything nice about you?
No, not at all.
And how would you describe your relationship as of today?
Objection, relevance.
With my ex-husband?
Okay, let me interrupt.
If it's my
Is the
Sure.
mystery witness in the waiting room her ex-husband?
He is the father of her children, yes.
and her
Okay,
ex-husband,
I'll overrule the objection.
what is the relationship of your ex-husband and you as of today, Miss Melvin?
It's horrible. It's horrible. We do not get along at all.
When is the last time actually you all have consistently been in litigation?
Yes.
Will have frequently been in litigation, correct?
Yes.
Okay. And he has the means to afford an attorney, correct?
Yes.
Do you have the means to afford an attorney to fight a custody battle?
I do not.
In fact, my representation as it relates to you today is appointed by the court, is it not?
Correct.
When it comes to Miss, the attorney and guardian ad litem asked you about how the visits affect Lexi. You recall. How do those visits go when you're with visiting with Lexi?
I really think they go well during the visit. She's always happy to see me. She's very happy. She's in great spirits. They've been well. It's short of the interference from the supervisor, from Miss Dickey, they're very positive.
And how many times has the CASA worker told you that Lexi has outbursts as it relates to your visits?
It's the first time I've ever heard it.
How many times has the CASA worker provided you feedback on her concerns with visitation?
She never has.
As it relates to, let's see, are you available to exercise supervised visits if the court were to grant this?
I'm sorry, could you repeat that?
Yes, are you available to exercise supervised visits if the court was to grant this?
Yes.
Are you available to exercise weekly visits with Lexi if the court were to grant this?
Yes.
Now, you have requested that the court provide either like a scram monitoring or the like in order to monitor your sobriety, correct?
Yes.
And would you like the court to order this to further make a showing of your sobriety?
That would be fine.
If those are installed, can you let the court know what you believe those findings will be as it relates to your sobriety?
They will show that I am still sober.
Objection, Judge calls for speculation.
Overruled.
Miss Melvin, what do you believe the findings will be of those tests?
It will prove that I am still sober.
Speculation.
Okay. I'll overrule the objection, and I'll also say, Ms. House, obviously, I don't believe that your client is going to answer that question by saying, "Oh, I think it'll show that I'm getting drunk every night," and totally torpedo my case. So please move on.
Right. And Ms. Melvin, by the same token, if you knew that those results were going to come out positive, would you ever request the court to install this, to implement this system?
No, I don't. I wouldn't.
Argumentative.
Was that an objection? I couldn't hear the response.
Yes, objection compound and
Okay, overruled. Let's move on, please.
Would you, Ms. Melvin? I don't think she answered the question.
I would not request it if I didn't think that it would prove my sobriety.
Okay. And if your ex-husband allows you access to your children, would you like for Lexi to have visits with your biological children?
Absolutely.
Because she's the last child that you're able to physically have, correct?
objection asked and answered.
Overruled.
I'm sorry, the question?
Is Lexi the last child you're able to physically have?
Yes.
And how many of your children, as to how many children have your rights ever been terminated?
None.
Thank you. No further questions.
Ms. Merritt?
Miss Melvin, are you employed?
I'm not.
How long has it been since you've held any employment?
A few years, 3 years maybe.
And what were you doing when you were employed?
Objection.
I had a little part-time job.
Okay. Go ahead, Ms. House.
I had a part-time job at HEB.
Okay, I said Ms. House. Is there an objection?
Objection. Relevance.
Ms. Merritt?
Judge, it goes to her ability to not only pay for any issues in here.
Go ahead, Mayor. Your next question.
So do you provide food for yourself, Miss Melvin?
I do.
With what money?
Objection.
I'm gonna, this whole line of questioning, this is not about a fight between two parents about which one of them should get the child. This is just about whether Ms. Melvin's prohibition against seeing the Lexi should be lifted. I don't think that's relevant.
And judges, there's already been testimony that
and I've already overlooked the line of questioning, so I don't need any piling on. Your next question.
No further questions, Judge.
Ms. Pearsall.
Thank you, Honor. You testified earlier that you're currently on step 12, and you recited to that.
Objection, Judge. That goes outside of the scope of redirect. So that we've already been past that point. She should have asked those questions prior.
Ms. Pearsall.
Judge, it's the state of Texas, which doesn't limit recross, and I haven't asked her about this.
Okay. Did you make that same objection earlier?
She did.
And it was overruled.
I don't think so.
Right, overruled. Go ahead. Please ask the question here.
Thank you, Honor. When you previously testified about step 12, what did you not tell us about step 12? What else does step 12 entail?
Step 12 is having a spiritual awakening.
That's part of step 12. What else is step 12?
I'm sorry?
What else is included in step 12?
What else?
Judge, are we here for leading questions or open-ended questions? It's my understanding that this is cross-examination and not direct.
Okay, I'll overrule the objection if that is one.
Ms. Wellen, do you know what else is involved in step 12?
That my understanding is that once you get through all the steps, then you would have a spiritual awakening. And like I had tried to answer earlier,
so you don't know what else is involved.
Objection asked and answered.
Hasn't been answered. Okay, tell this court what step 11 was.
Step 11 is. I'm sorry.
All right, Ms. Pearsall, if you have a direct question, that's fine. I'm a member of Alcoholics Anonymous, and I could rattle off all 12 of the steps in a row. Okay.
Judge, you could, but I believe Ms. Melvin can't.
I said I couldn't. So I'm going to overrule that as irrelevant. This isn't here to test your memory about what the steps are at each one. If you want to remind her what a particular step is and ask her if she really has done that, that's fine.
I'll move on, Judge. Now, during this alleged coronavirus infection by your husband, that lasted for about 3 months, correct?
Yes.
And during that period of time, you had visits with your daughter on Google Duo. Isn't that true?
Yes.
And you missed every one of them. Isn't that true?
That is wrong.
I'll pass the witness.
Ms. Sims?
Nothing further, Your Honor.
Okay. So is that it?
Yes, Judge.
All right. Any other witnesses?
No further witnesses, Judge.
Argument? Let me ask Ms. Cavazos, do you need a break before we launch into this? Go ahead. Ms. Merritt, I guess.
I'm sorry, Judge, I didn't.
Argument? Or any other witnesses from anyone? You had a rebuttal?
I do have.
Yes, Your Honor. The person who you put in the waiting room.
All right. What is your name, sir?
My name is Matthew Gothard.
Can you spell the last name?
Yes. G is in goat, O is in Oscar, T is in Tom, T is in Tom, H is in house, A is in alpha, R is in Romeo, D is in dog, T is in Tom.
All right, just like it sounds, but I wanted to make sure. You solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, Ms. Pearsall, briefly.
Thank you, Your Honor. Matthew, how are you related to Miss Melvin?
Well, I am her former spouse or husband.
Okay. Briefly, why are you no longer married to her?
Objection, relevance.
Sustained.
Is there a current court order between you and Miss Melvin about your children?
Yes, ma'am.
Okay. And do you have custody pursuant to that court order?
Yes, ma'am.
Okay.
Judge, may I ask, before we get into this questioning, if Mr. Goddard has had the ability to speak to an attorney about his Fifth Amendment right, not to testify against himself, when it comes to interference with child custody?
You're trying to intimidate the witness.
No,
Okay.
I'm actually trying to
All right.
protect the witness.
Okay. Mr. Goddard, I'm asking you to unmute. Can you hear me, sir? Please unmute your device, your telephone.
You may need to hit *6.
Judge, and I don't believe any testimony could possibly go in that direction. And I believe this House is just attempting to intimidate a witness.
Okay. Mr. Goddard, I believe you may be asked some questions that might tend to show that you have not followed the court's order with regard to access to the children by Laura Melvin. I can tell you that. Oh no, sir, I'm speaking. I can tell you that.
No,
Yeah, sir.
I have a court order. And that's what I.
Okay, Mr. Goddard. There is an offense in Texas called interference with child custody. I can't tell you that it's prosecuted very often, but I certainly have had cases come before me where people are charged with interference with child custody, where parents are. I need to tell you a couple of things. The first of all is that you have the absolute right under the Fifth Amendment to the U.S. Constitution and under the Texas Constitution to not answer any questions that might tend to show that you've committed a criminal offense. But you must either answer the questions or assert your rights against self-incrimination. You can't answer a few questions that might show perhaps you violated a court order as far as access and possession of children, and then decide that you don't want to answer any more questions along those lines. Okay. So the other thing I need to ask now is, do you wish to assert your Fifth Amendment rights? Do you wish to consult with an attorney before you make that decision, or are you willing to give up your Fifth Amendment rights, not as to any offense you might have ever committed in your life, but just as to whether you have complied with the court's order on possession and access to the children?
I believe I'm capable of answering these questions. If not, well,
because all I want to know is, are you telling me you're waiving your Fifth Amendment rights, you're standing on them, or you want to talk to an attorney?
I'm waiving my Fifth Amendment right to, and if I need to use it, I will assert it.
No, sir.
I can't imagine
what I just explained to you, sir, is that you must either assert it or not assert it. You can't answer a few questions that might tend to incriminate you and then decide, hey, I don't want to answer more of these. It must either be asserted or not asserted. So are you, are you
ask me your questions. If you're asking me questions.
All right, Mr. Goddard, the only thing that you get to know in advance is that it has to do with whether you've violated a court order about possession or access to your children, all right? And you must either say that you're going to waive your Fifth Amendment rights, you're going to assert them, or you wish to consult an attorney first. You, like I said, you can't answer some of the questions and then get to one and say, well, now I want to assert my rights.
Judge,
So
I believe
Okay,
somebody.
I'm gonna waive my rights, okay?
All right, go ahead, Ms. Pearsall.
Thank you, Honor. Okay. So I believe the question was, do you have a court order with Ms. Melvin about the children?
Yes, I do.
And does that court order, in addition to giving you primary custody, give certain visitation to Ms. Melvin?
Yes, it does.
Okay. Does Ms. Melvin have supervised or unsupervised possession with your children pursuant to that court order?
Okay, she has unsupervised visitation if she meets some criteria, and she has never met that criteria.
Okay. How long has the current order been in effect?
This current order has been in effect since October 28th of 2018.
Okay.
I'm sorry, 26.
Okay. And so what are the conditions that Ms. Melvin is supposed to comply with in order to see the children?
Yes, ma'am. One, she is supposed to, if she is going to transport them, she has to have a ignition interlock.
Okay. Has she ever provided you with proof that she has obtained an ignition interlock?
No.
What if any requirements are in your order about Ms. Melvin submitting to hair follicle tests?
Yes, she was supposed to provide me with a hair follicle test. I would be responsible for paying if it was negative, and she would she would pay for it if it was positive, and I would pay for it if it's negative. I have never received any indication that she has taken a hair follicle test.
Okay. What other requirements are in your order?
The other requirement is for her to get some technology referred to as SoberLink. This is essentially the same thing as ignition interlock, but it attaches to your phone, and she would need to breathe into it 2 to 3 times while the children are under her supervision.
Has she ever, between the day this order was entered and today, provided you this proof that she has obtained that on her phone?
She has never provided any information. She has done that to me or my lawyer.
Okay. Now, you have 2 children with Ms. Melvin who are still under 18. Is that correct?
That is correct.
Okay. You had an older son with her, but he's now an adult, correct?
He
Now
is, yes, he is an adult.
Okay. So let's talk about your 2 kiddos, Corbin and
May
Holt.
I take a 5-minute break? I need to go to like a restroom break, please.
Yes, we'll come back at 6:25.
Thank you.
May I proceed, Jonah?
Yes, I'm here.
Okay, I'm sorry, I had my speaker muted. Is everyone ready to proceed?
Yes, Your Honor.
Yes, Judge.
Yes, Judge.
Go ahead, Ms. Pearsall.
Thank you, Your Honor. Mr. Gotthard, in your order, the breathalyzer machine in Ms. Melvin's car, was she ordered to pay for that in your order?
Yes.
And the phone system to verify 3 times a day whether she was drunk or not, was she supposed to pay for that in your order?
Yes, ma'am.
Okay. Was she also ordered to provide health insurance for your children in the order?
Yes.
Okay,
Objection relevant.
I don't need to hear this testimony on this question.
Okay.
That doesn't go to the safety of anyone.
Has Miss Melvin had the children for a weekend at any time in the last, let's say, year?
No, ma'am.
Has Miss Melvin had the children for 30 days in the summer, last summer?
No.
And if she testified under oath that she did, would that be a complete lie?
Yes.
Okay. And if she testified under oath that she had the kids for multiple unsupervised weekends, would that be a complete lie?
That would be true for the last year.
I'm sorry, what would be true for the last year?
It's been more than a year since she's had an unsupervised visit.
Okay. Now, why does your order have all of these stringent requirements? Why are you concerned for your children's safety in around Miss Melvin?
Miss Melvin had a long history of abuse of prescription drugs, and then I received information that she had a public intoxication, and then she'd also
Objection, hearsay.
All right.
Excuse me.
Okay,
I have a copy. I have a copy
right,
of
sir.
of.
I'm going to instruct you, Mr. Gotthard, not to argue with me. Ms. Pearsall, do you have a response?
Judge, he was her husband for 10 years. He knows what her criminal history is, and he was last litigation with her 2 years ago. So he is personally aware of her addictions and her criminal history.
And Judge, he
Mr.
testified.
Gotthard, you can answer as to your personal knowledge of things, okay? So please answer as to whatever your personal knowledge is.
What is my personal knowledge?
Yes, and please repeat the question.
Sure. Mr. Gotthard, based on your personal knowledge, what concerns do you have about Miss Melvin being around your children?
I received information that she had been arrested.
That's not an answer, okay? The question is, what are your concerns? Not why you had those concerns or when those concerns developed. What are your concerns?
My concern is that she would not, that she would be under mood influencing substances while the children would be under her care.
And why are you concerned that she would be, I don't know the right word is intoxicated or high while she had your children? Why do you have that concern?
Objection, compound question, and objection. Facts not in evidence. Objection, it's a misstatement of the testimony.
Ms. Pearsall?
It's a why question. I'm asking why, Judge. He can explain his answer.
You said high or drunk, and that's not what he said.
All right. I'll ask you to divide it up between alcohol intoxication or anything else, Ms. Pearsall.
Sure. Why are you concerned that Miss Melvin would be intoxicated while in possession of your children?
I have no indication that she would do anything different while the children are in her care, that she was doing what I was aware of, when they weren't in her care.
Okay. And what do you know that she was doing that causes you that concerns? What was she doing that makes you concerned about her drinking?
And Judge, may we ask time and scope of the information he's providing to ensure we're not going behind the last order?
Excuse me.
Okay, Ms. Pearsall?
Right here. Harvey
Judge,
finished with.
Judge, she's the father of her children.
Okay. This is about why he has the concerns all over the objection.
Mr. Gotthard, you can unmute and answer the question.
Okay. Yes.
Do you need me to repeat the question?
Yes, please.
Okay. Why are you concerned that Miss Melvin is still drinking excessively?
Because I'm I'm not aware of that her history or anything that has changed when I was in closer contact with her and aware of her behavior.
Okay. And based on what you know about her behavior, do you also have concerns that she might be getting high?
I am not in her presence. So all I know is that in her past history, she did not have the ability to control herself with mood influencing substances, and I have no reason to understand why it would change. If I was aware of that, I would, and she had her lawyer contact my lawyer. That's something we could discuss, but I have not received any indication.
And when you say mood influencing substances, can you tell the court what you're talking about?
Well, it could be alcohol. It could be prescription pain pills. Beyond that, I have not been in Miss Melvin's, presence to be aware of anything else.
Right, and I'm just asking about what you know. Okay.
Yes, ma'am.
And when you say that her lawyer hasn't contacted your lawyer, who was Miss Melvin's lawyer during that last lawsuit?
Objection, relevance.
All right. Ms. Pearsall, I understand that this house is court appointed and Ms. Melvin's testified she can't afford an attorney.
Well,
Judge,
Ms. Melvin also testified that she didn't have an attorney, which is not true.
Well, I understood her testimony to be that she doesn't have an attorney to go back to court and fight for what she testified was Mr. Gotthart's failure to follow the court order. So please move on.
Okay. Are you aware of Miss Melvin's criminal history?
Objection, relevance.
Okay. All right. I understand that Ms. Melvin has had significant issues with prescription drugs and alcohol. The question is whether there's a present concern about her access to the child. So, Ms. Pearsall, if it's only has to do with prescription drugs, alcohol, and not injury to a child or sexual contact with a child or something, I'll sustain the objection. So what kind of information are you trying to get in?
No, Your Honor, it's just multiple DWIs. I'll move on.
Objection, that's a misrepresentation of the facts. I also object to your defamatory comments.
Oh, okay. Address yourselves to me and not each other. I'll overrule the objection. Let's go on.
Thank you.
I've already overruled the questions.
Mr. Gotthard, is one of your children graduating tonight?
Yes.
Which one?
Matthew.
Okay. And because of coronavirus, were there limited tickets given to each family?
There is limited seating. Yes.
Okay. So how many tickets did Matthew?
Okay, Ms. Pearsall, I don't need to hear about this. I don't know where it's going, but it has nothing to do with the safety of Lexi. Your next question.
Judge is going to another line, Ms. Melvin told you.
Okay. Your next question.
I have nothing else, Your Honor.
Ms. Sims? I'm sorry, Ms. Merritt first.
No questions, Judge.
Ms. Sims?
No questions, Your Honor.
Ms. House?
Thank you, Judge. Mr. Gotthard, when's the last time that you've reviewed your order in suits to modify the parent-child relationship?
When's the last time I reviewed it?
Yes, sir.
About 5 minutes ago.
Okay. And so I would like to admit what I will be Laura Melvin's exhibit number 1, which is a certified copy of your order in suit to modify the parent-child relationship. But Judge, I can chat it and drop it in the chat.
Judge, and she hasn't provided it to any other attorneys.
All right, please provide a copy of that to everyone. And let me ask you first, Ms. House, what's the date on this order you have?
February 21st, 2019. And it's a certified copy.
Okay, all right. Mr. Gotthard, what is the date of the order you've been referring to?
February 21st.
Okay.
Of
2019.
All right, so please
Yes,
post that to
correct.
everyone, Ms. House. We'll give the attorneys a chance to look at it.
Thank you, Judge.
I've received from Ms. Sims. I have not received it from Ms. House, but Ms. Sims just forwarded it to me.
Okay, so but you have a copy from somewhere?
I do, Ms.
Okay, so are you objecting to this?
No, Your Honor.
Okay. I'll take judicial notice of my own signature and admit Ms. Melvin's number 1.
Thank you. Mr. Gotthard, do you see the screen?
Well, no, I don't see the screen, but I do have a copy of, I believe, the item y'all are talking about. I am on page 9.
Okay, I am going to, now I want you to turn, please, to page 3. You and Miss Melvin were appointed joint managing conservators, were you not, sir?
That's correct.
Okay, and we are going to go over the provisions you were referring to on page 9, okay?
Yes, ma'am.
All right. All right. Number 1, it stated that, actually, I'm just going to refer to what you were referring to. You stated that, number 3, you were talking about ignition interlock.
That's correct.
And were you aware that Laura Melvin does not drive a vehicle currently? Yes
no,
or no?
I'm not aware of it. No.
And were you aware, yes or no, that Laura Melvin has not operated a vehicle for quite some time?
No.
Okay. And in fact, you have never recently seen Laura Melvin operating a vehicle. Is that not also correct?
That would be correct.
As to the drug test that you were talking about, number 4.
Yes.
Mr. Gothard, you were the petitioner in this suit, were you not?
That would be correct.
According to number 4, Mr. Gothard, you stated till this day, Laura Melvin has never provided a drug test to you, correct?
That is correct.
Okay. What facility, Mr. Gothard, did you pay for so that Laura Melvin could submit to a hair follicle test?
Is this particularly relevant?
Sir, answer the
You're
question.
reading that. Okay. No, I have not.
Okay. And sir, that would be a violation of number 4 because according to this order, sir, you were supposed to pay for the test that Laura Melvin was to submit to. Were you not, sir?
Your Honor, I would object. That's a total misstatement of the order. It gives him a right to request it. It's not a violation if he didn't request it.
Wait, what?
Okay, so I will sustain that objection and allow you to inquire about whether he's ever requested that she take a test.
Mr. Gothard, have you ever requested that Laura Melvin take a hair follicle test to determine use of illegal substances?
Only through this document. Yes, ma'am.
Wait, you're saying that you made your request through this document?
Yes, ma'am. When she wants to pick up the children, she would contact my lawyer that she has satisfied the requirements that we agreed to in this contract.
Okay. Mr. Gothard, according to this order, it states that Laura Melvin, that Laura shall within 5 days of a request have a hair follicle test. When have you or through your lawyer requested after this order that Laura Melvin submit to a hair follicle test?
Objection asked and answered.
I have
overruled.
Go ahead.
Okay. I have not asked for a hair follicle test because she has not asked.
Okay.
Or, she has not contacted my lawyer that she's met these requirements for me to to let the children be under her supervision.
Okay, Mr. Gothard. And as far as is it your testimony to the court, Mr. Gothard, that you've not turned over the children to have a visitation with my client since this order has been issued?
That would be correct.
Is it your testimony that during the time, let me ask you, what was your understanding as the type of visitation Ms. Melvin was to receive before fulfilling the condition requirements?
None. He would contact my lawyer. My lawyer would bring me up to date that she had fulfilled the conditions, and I would let her have visitation with children. It's pretty simple here.
So when's the last time you were stating that Laura Melvin has physically seen her children?
She saw one of her children last week on Thursday. I'm not aware of exactly what the date was.
What age was this child?
This child is 10 years old.
Okay. And what were the circumstances of the visit with that child?
This is a school function.
But I thought you testified to the court that Laura Melvin hasn't seen her children.
Objection, Your Honor. What he testified to, it's
Yeah, I'll let overrule the objection. You can answer the question.
Okay. Miss Melvin has not had unsupervised visitation with the children.
Okay, Mr. Goddard, have you had the opportunity to review this? Let me ask you, when we leave today, will you review this order with your attorney for a understanding of the orders that were issued by the court?
Objection, improper question, and I would assume that would go into his attorney-client privilege.
I mean,
I'll overrule the objection.
Sir?
Okay. I'll ask my attorney if Miss Melvin has contacted her, or some legal representative has contacted her that she has met the conditions of this mediated agreement.
And Mr. Goddard, when is the last time you don't know about Miss Melvin's current therapeutic?
No, ma'am, she has not contacted my lawyer with what her situation is.
Thank you so much, Mr. Goddard. No further questions.
Okay.
Thank you, ma'am.
Any other questions for this witness?
Yes, Your Honor.
Go ahead.
Thank you, Your Honor. Mr. Gotthard, pursuant to this order, and I'm still on page 9, Ms. Melvin was ordered to attend a 12-step. Did you ever get any proof that she's done that?
No, ma'am.
Okay. She was also ordered to attend counseling 2 times a month with a children's counselor prior to any unsupervised visits. Has she ever done that?
I never received notification, no.
Okay. And you take your children to their counseling, correct?
One of the children is still attending counseling, yes.
Okay, so you would know if she suddenly decided to care enough to see the children's counselor, wouldn't you?
Objection argumentative.
Sustained.
Okay. I don't know.
Sir, let Ms. Pearsall rephrase the question.
Sure.
I'll pass the witness, Judge.
Any other questions, Ms. Merritt?
No questions, Judge.
Hello?
Sorry.
Ms. Sims, hold on, sir. Any
No
questions? I'm sorry?
No questions, Your Honor. Thank you.
All right, Ms. House?
Briefly, Judge. Mr. Goddard, what is the name of the children's counselor?
The counselor that he is seeing now is at Courage Ranch.
And how frequently does this counseling happen?
Objection, Your Honor, relevance.
I'll just allow the question. Go ahead.
Once a week.
And which child is this?
This would be Corbett.
And when did you notify Miss Melvin that this is where he attended counseling?
Objection, relevance.
All right, what's the relevance?
Judge, if they're trying to use this against her, if she's not attended any counseling session, I believe it's relevant whether or not Mr. Goddard is sharing information to even engage.
I'll the question.
Judge, the order specifically says the counselor's name that she's supposed to contact. It's in the order on page 9, paragraph 2. So the question
is that the same counselor now?
Well, that's the counselor that she's ordered to contact. The name is in the order.
May I ask that, Judge?
Okay, I'll overrule the objections. You may ask that question.
Mr. Goddard, is Elizabeth Tofani Garcia the current counselor that's providing services right now?
No, she referred Corbett to this other program.
Did you send that referral information to Laura Melvin in writing?
No,
Did you request that your lawyer send the counselor information to Laura Melvin?
no, I didn't.
Why not?
Objection relevant.
Okay, I'll sustain the objection. Obviously, the lady can't be blamed for not attending counseling she hasn't been informed of.
Okay, no further questions, Judge.
Okay, you are excused, sir.
Thank you. Y'all have a good day.
Any other witnesses from anyone?
Judge, I just want to, with the scope of the information provided by Mr. Gothard, I'd like to recall Laura Melvin as it relates to his testimony alone.
Go ahead.
Thank you. Okay, Laura Melvin, according to this order on page 10, it was ordered that you shall have protection of the children effective immediately.
Right.
Under what was called phase 1, correct?
Right. Yes.
You were supposed to have the children from 10 a.m. to 6 p.m. on Saturdays on the 1st, 3rd, 5th weekend of the month with exchanges at Dairy Queen in Pettis, Texas, correct?
That's correct. That was supposed to have happened.
And would you show up to Dairy Queen to exercise phase 1 visits?
Yes.
Would Mr. Gothard show up?
No.
And according to him, you heard him testify. You weren't supposed to be getting any visits until you followed all of those requirements as outlined in that order, correct?
Correct.
Okay. Ms. Melvin, do you currently operate a vehicle?
No, I do not.
And it's been quite some time since you've operated a vehicle, correct?
True.
Have you received written notice from Mr. Gothard requesting that you submit to a hair follicle?
No.
And have you received information on the counselor that is providing services to your children?
No, I was only aware of Miss Garcia, I think it's her name. And we met with her one time, and then there were supposed to be follow-up meetings, but he refused to go.
Mr. Gothard has stated that you have not had unsupervised visits with your children, the minor ones. Is that correct?
That is not correct. I have had visits.
And can you explain to the court, actually, never mind, no further questions.
Okay. Any other questions?
Ms. Melvin, you never provided, I'm sorry, I thought somebody said something. You never provided the proof that you were attending the 12-step program to Mr. Gothard, did you?
There is nothing in this order that says that I have to prove it. It just says that I have to attend for 12 months, and I did. I'm still going.
Okay. Just like you've never provided proof of your attendance to the department throughout this case, isn't that true?
That's not true.
And so your testimony under oath is that you've never had an ignition lock in your vehicle, correct?
No, I never said that.
Okay, so have you had an ignition lock in your vehicle?
I did.
Okay. When did you have the ignition lock?
I don't remember dates, but I had it up until I stopped driving.
Okay, when did you stop driving?
Ma'am, I just said that I don't remember dates, but it's been quite a while.
Well, it's quite a while, 2 months, 5 years?
Over a year.
Okay, so you stopped driving a year ago?
Approximately.
Objection, she said over a year.
Okay. I'll overrule the objection. Please move on, Ms. Pearsall.
Why did you stop driving over a year ago?
Personal choice.
Do you still have a valid driver's license?
No, I turned it in and got an ID card.
Okay, so you currently do not have a valid driver's license?
No, I do not.
Did you ever install the sober link on as required by this order?
No, there was
Ms. Melvin, you answered my question.
No, I did not have to sever that.
And during this case, you were represented by Attorney Grace Brenner, correct?
True.
No other questions?
Ms. House or anyone else?
Yes, Laura, can you please explain the sober link requirement to the court?
There was a
Objection. Your Honor. Best evidence rule. The order speaks for itself, and she's definitely not qualified to interpret it.
I'll rephrase.
Please rephrase.
Miss Melvin, did you install the sober link into your vehicle?
yes. When I was driving, I had the interlock.
Okay, so there was sober link and there was the ignition interlock, correct?
Right. And it was agreed upon.
Concept.
Overruled.
Go ahead, Miss Melvin.
It was agreed upon that as long as he was getting the information.
Okay. Well, let her answer the question before you interrupt, please.
Judge,
We
I don't
see
even
that,
think there's a question asked.
There was.
Okay. I'll overrule any objection at this time. Please answer it. Please repeat the question because I forgot what it was.
Explain to the court how you complied with the sober link provision.
It was agreed upon that as long as he was receiving the information from interlock, then I wouldn't have to do the sober link.
Okay.
That was agreed between our attorneys.
Okay, because this order had ignition interlock and sober link as a requirement in this order, correct?
I believe it does state that way.
Okay. No further. Laura, and to address what Alana Pearsall was asking, as of today, can you afford to hire I've already asked that. Never mind. No further questions. Pass the witness.
I have one question, Ms. Melvin, or two questions. One, the interlock that you testified you had in your vehicle, was that in response to the lawsuit concerning your children, or was that as a result of a criminal probation?
It was part of probation.
And my other question is it your testimony that you were in compliance with this order that I signed in October of 2000, whatever it was, 19, I think, but that it didn't say you had to provide proof to your ex-husband and you would rather not provide that proof to your ex-husband than have access to your children?
No, I wouldn't have. I wouldn't have minded providing the information, but at that time, it didn't say that I needed to give him anything, or I didn't need to get a sign-in sheet or anything like that. It just said to attend. So I just did it. I just followed the order.
I'm not asking if you follow the order, ma'am. I'm asking if it was your decision that not allowing your ex-husband to dictate to you that you had to provide proof you'd complied with the court order, that not allowing him that little victory was more important to you than seeing your children.
Oh, no, I don't really consider it. No.
So then why didn't you do it?
I'm sorry?
So why didn't you do it and see your children?
He never asked for it.
Okay, other questions for this witness?
No, Your Honor.
No, Your Honor.
I do, Judge.
Go ahead.
Ms. Melvin, had you provided proof of NAAA based on Mr. Gothard's understanding of this order, do you believe it would have made a difference as to whether or not you would have had access to your children?
Objection.
No, I don't.
Speculation.
Overrule the objection.
Go ahead, Ms. Melvin.
No, I don't. It wouldn't have made any difference.
Because in fact, along with NAAA, he believed you had to satisfy every other condition in order to see your children, correct?
Correct.
Including the fact that he thought you were supposed to pay for a hair follicle drug test and provide that information to him, correct?
Objection.
Correct.
A statement of what he testified to.
That is it.
I'll sustain the objection.
No further questions. Pass the witness.
Okay. All right, if there's nothing else, argument?
Yes, Judge. Do I get the bonus of going first?
Yes.
Judge, thank you for listening to what could have been a 4-hour hearing that has morphed into a very, very long hearing. I appreciate you listening very carefully to the evidence and to the testimony through taking care of your son, as well as the allergies you very much seem to be suffering from. The department, Your Honor, is asking for the court to keep the status quo. You've heard enormous amounts of evidence that Miss Melvin is in compliance when she wants to be in compliance. She has blamed the department. She has blamed Miss Bobby Garza. She has blamed Judy Dickey. She has blamed her ex-husband. She has blamed everyone for her failures and has not taken very much responsibility for herself. Judge, she has missed numerous drug tests, nail tests, UAs. She has missed counseling. She's missed several counseling. She has not provided the department with NA and AA sign-in sheets. And you've heard the testimony of Judy Dickey indicating that she felt that it was not in the best interest of this child to continue to have any kind of visitation with her mother. Judge, we are set for trial in little less than probably 45 days. And Your Honor, I don't believe that allowing for having a scram monitor or a drug patch provided to the department, who has provided a lot of services to Miss Melvin, including a psychological evaluation, a psychiatric evaluation, at least 2 to 3 different counselors, afforded her to take those sessions by video and telehealth and telemed, by Zoom, by Google Duo, by KidShare. And Judge, she's not consistent. She's not consistent in her drug testing. She's not inconsistent in her former visits with her child. She was not consistent with her counseling. I think the most positive thing that I've heard over the last, day and a half is that she's made the last 4 counseling visits and wants to go for 2 hours. And mind you, the 2054 that is in place is not allow for that, but I'm happy that she's doing that. I don't believe that the Department of Family and Protective Services or the citizens of Karnes County or the state of Texas should have to pay for a scram monitor or drug patches for Miss Melvin to prove that she's drug-free and sober. She's had approximately since November of 2019 to prove these things, and she hasn't. The department, if you read I'm not sure, the MSA is not entered into evidence, but it indicates the department can file for motion to modify at least with, as long as 6 months has gone by. The department didn't file at the 6-month mark. And Ms. House made that distinction. The department took the time, gave Miss Melvin an opportunity to show that she has a relationship with her child, that she can continue to be drug-free and sober, whether it's benzodiazepines, whether it is alcohol, hydrocodone, whatever. And she hasn't done it. And Your Honor, I don't think that it's in the best interest of this child, a child who has special needs, to continue to have to go for a visit where mom may not show. And we don't know when she is or when she's not. She had, under the MSA, weekly KidShare visits from 9 to 10, and she missed a heck of a lot of them. I just don't see how it is in the best interest. However, if Your Honor is going to order visitation for Miss Melvin, I would strongly recommend that Miss Dickey stay as the supervisor, as that is a person that Lex is familiar with, is comfortable with, and has been seeing since April of last year. To have another person come into her life and try to create a bond, to create an understanding of the relationship between Miss Melvin and Lexi, I think is too traumatic for a child. And we would ask that Judy Dickey remain on it. Again, Judge, the department does not feel that it should have to provide for a scram monitor or drug patch. We never have. We do not have the funds to do so. And, that is not something that our budget at this point in time can take. Those are the department's arguments at this time. Thank you for your time.
You're on mute, Your Honor.
Ms. Pearsall?
Thank you, Your Honor. Judge, thank you very much for listening to us, and I hope, I'm sure with everyone else, that you feel better. I think most of us suffer from allergies who live in Texas and absolutely hate them. So thank you for staying late, especially that you're not feeling well. As far as this case, I actually agree completely with what Ms. Merritt said. Ms. Melvin, through her testimony, blamed every single person for what got her here and everything she has and hasn't done. But, more importantly than the fact that she refuses to accept any responsibility for anything, and that, her bad visits is the therapist's fault, and, her not calling into visits is the coronavirus fault, and, her failure to attend therapy is therapist's fault, is what she told you today is that her child's fetal alcohol syndrome is not her fault. I mean, all these years of alleged attempts to do anything in her service plan, she still refuses to acknowledge that very first step. Her kid is really ill and will be ill for the rest of her life because of her choices. And she's never taken any responsibility for it because nothing is her fault. And it makes no difference to her how this affects her poor child, just like it made no difference to her while she gave this child this condition for 9 months. This case isn't about Ms. Melvin and what she does and doesn't want. This case is about the best interest of Lexi. And you've heard from the people, the unbiased people who are here just for the best interest of Lexi. And that's Ms. Dickey, Lexi's therapist. And she told you after over a year of counseling with Lexi and after supervising multiple visits with Ms. Melvin, the one she chose to show up to, she believes it is emotionally harmful to Lexi to restart those visits. She believes it will be traumatic. She believes as a child's therapist, it will set Lexi back in her behavior, in her education, and in her development. You also heard from Ms. Hicks, the foster mother who has raised this child for most of this child's life. She's had this child 4 times longer than Ms. Melvin ever did in her home. And she told you what happens after those visits. Lexi suddenly starts kicking the dog. She gets consistently in trouble at school. She scratches at other people in the household. And yet when those visits stop in December, this kid suddenly behavior improved, her listening skill improves, her grades improved, her education improved. She is a different child now that she's not subjected to Ms. Melvin. And then finally heard from CASA, who is a child's guardian and has been for over 3 years. And she told you that in her opinion, restarting those visits isn't only against what Lexi wants, but more importantly is harmful to her, traumatic to her, and is not in her best interest. Judge, I will tell you, in my opinion, that it's actually worse than harmful. At this point, these visits for Lexi have been cut off in December. We've had over 5 months of no visits. And we are looking at a termination trial in about 43, 42 days, give or take. So to potentially reintroduce the woman who upsets this child and causes her to act out after 5 months of no contact, and then to permanently terminate and cut her off for the rest of her life in 40 days is cruel. It's not only in her best interest, it's cruel and it's mean, and it's guaranteed to have negative effects for the child. I also agree with Ms. Merritt that, these asking for an ankle monitor and asking for a patch is a little too late. The only reason we are here, and the only reason this is even an issue today, is 3 years of UAs, hair follicles, nail test, 3 years of Ms. Melvin failing to do all the tests that the department was paying for, all the tests that the judge repeatedly ordered her to do and that was required in her service plan. That's why we're here. So to come right before trial that's been postponed for this long because of her jury demand, and say, okay, well, now I want somebody else to pay for something, is unfair, Judge, and quite frankly, it's prejudicial for a jury that's about to hear this case and is going to get very confused as to why this happened. And when we order, and I would also point out that Ms. House filed this motion and said, we'll agree to a monitor. Well, there are different types of monitors. An ankle monitor, if the court is going to order anything, I think is the only option in this case, because anything else she can get her husband or her friend to blow in. Ankle monitor is the only one that we actually know will be hers. And if you look at my proposed order, I have very specific orders in there about the fact that it specifically has to be that, and it has to be attached, and she has to have an ID and things like that. As far as the patch, Judge, it's my understanding the farm check drug patch is the only one that tests for her addiction of choice, benzos and hydrocodone. So there's multiple patches, but my understanding is this is the only one. When we have a person who engages in criminal behavior, which is the only time that I know of that this type of remedy is available, in those orders, that defendant is ordered not only to have these items, but to pay for these items, because it's their fault they were drinking and driving. It's their fault they had public intoxication. It's their fault they did whatever they did. And it's Ms. Melvin's fault that she has failed to comply with a million drug tests that were requested and she's chosen not to do. So to order anyone else to pay for a, Judge, with their tax dollars isn't right and isn't fair. Ms. Melvin has paid for nothing in this case. She's not paying for her attorney. Her husband has had a job for 24 years, obviously making a decent living. Her house that she lives in is paid off. If she wants to finally do something to prove it, then she needs to bear the responsibility of doing it. So I would ask, one, and more importantly, for Lexi's sake, that you please continue suspending those visitations and that none be granted today. And two, that the request for the monitor be denied. But if the court chooses to do so, I would ask that you require both alcohol monitor and the patch be ordered, and that Ms. Melvin be ordered to pay for those. Judge, I believe based on her history, if you only order one without the other, she's guaranteed to switch to the other drug of choice. And both of these substances, both of these tests test for different things, and there isn't one that tests for both.
Ms. Sims?
Thank you, Your Honor. As Lexi's attorney, I think it's my duty to speak for what she would want. And I don't believe she would want visits to resume after this time. Lexi did not want to be stood up for all of the visits that were scheduled, and Mom did not bother to attend for various reasons. Lexi wants stability and consistency, which she has now in her current placement, and it's her expressed desire to stay where she is. She is doing very well. Your Honor, also to the question that you yourself posed to Ms. Melvin regarding the order that you signed in her divorce regarding her prior children, Ms. Melvin has demonstrated time and time again that it's just not that important to her to have visits with her children to comply with an order. For whatever reason, she didn't feel it was necessary to demonstrate that she was attending NAAA meetings. And I believe that this is very telling to also her consistent behavior in this CPS case. It just hasn't been that important to her. Lexi has not been that important to her. She has not visited. She's not consistent. She is not consistent with her drug test or her other services unless we have a court hearing and she is specifically admonished by the judge to do something. Then we have a short period of compliance, and it's not fair to Lexi, Your Honor. We are so close to trial, and additionally, we do not have a recommendation for reunification that will be key at trial in going towards what is in Lexi's best interest for an outcome from a jury. I would ask that you not change her visitation at this time. However, if you see fit to reinstate some visitation, I would ask that it be very minimal, and that any ongoing visitation with the child require strict compliance. She can't pick and choose which visit she's going to attend, which is only confusing this child. And I think that her visitation also should be in line with her strict compliance with the service plan. If she can't comply within the next few days and attend all of the visits, if you see fit to order her to have so, then her visit should again immediately stop. I also agree with the department that Judy Dickey has been a source of stability in little Lexi's life, and she should continue to be the one to supervise visits. I don't believe that Miss Dickey is biased. I believe that she also gave some positive testimony to mom, and you heard a lot of positive testimony today. Laura has improved for a brief period, but it hasn't been consistent. And I don't know that she's going to be able to maintain this brief amount of progress that she made. It's absolutely detrimental to the child to have her go back and forth and give her whiplash with whether or not she's going to see mom, whether or not mom's compliant. I would ask you keep the orders the same. Thank you.
Okay, Mrs. House.
Thank you, Judge. I think this is a case of, we've asked the court that when we come and represent the court facts of a case, that it has to make sense. And every single turn, the department, the ad litem, the interveners have had a problem with making it make sense. First off, you have a 4-year-old child at that point, which a majority of the testimony is around a child at that time, she was 4 years old, who have adults who are using their adult words in place of what they think, what they feel, what they believe a 4-year-old child wants doesn't make sense. Not only that, Judge, there were testimonies about concerns about the visits, but let's talk about what the department and the ad litem and the intervener failed to provide to the court, right? Not one visit was stopped. Not one witness testified that the visits were stopped because of the behavior that mostly foster mom witnessed. The behavior cited in this case and the concerns were coming from a foster mom who filed her own intervention lawsuit seeking to terminate the rights of my client to her benefit, stating that the child was having outbursts, that the child was experiencing anxiety, that the child was experiencing behavioral issues, only support her lawsuit. And in fact, I asked her that, whether or not she believed that saying negative things about my client benefited her lawsuit. And she said, I suppose so. She agreed, Judge. Not only that, what doesn't make sense are the redundancy in services. The department wants to brush over the fact that they secured Ashley Martin to provide therapy to not only my client, but her husband to address issues in this case. She was successfully discharged from that. And when the department wasn't happy about that, then they bring in another therapist, whom for which my client, without complaint, has engaged in services. And in an attempt to mar her ability to show parenting skills, Alana Pearsall decided to subpoena this therapist who only had glowing things to say about my client's participation in services in therapy. In fact, he said, these are things that Laura Melvin already knew. Do you know why she knew, Judge? Because she had already did the counseling with Ashley Martin, who provided the type of intensive therapy that even the psychiatrist, Dr. Miller, said was excellent. Along with making it make sense, Judge, the department has taken a hard stance at trying to terminate parental rights of someone who has testified that she has remained sober since 2019. Not only that, the department can't testify that they have one positive test since my client went into inpatient rehab. You know why? Because a positive test doesn't exist. In fact, the last test requested by the department was a hair drug test for which she passed with flying colors and tested negative. Their stance, again, doesn't make sense. Next, we have medication management. The court found it concerning. Dr. Miller found it concerning that Laura Melvin was still on benzodiazepines, a medication that she didn't voluntarily put on herself, that her psychiatrist ordered that she be put on. And in compliance with these orders, Judge, I'm sorry, Judge, I don't know if I lost you.
No, I'm still here. Go ahead.
Judge, in compliance with the orders of the court ordered that Laura Melvin wean off of benzodiazepines, for which she did. And as evidenced and backed up by Dr. Miller, to expect that she wasn't going to experience side effects such as confusion, dizziness, illness, to expect her to be perfect during this weaning off period and just show up and always be on point is unrealistic. They asked for her to be weaned off, and then they don't want to accept the side effects that my client was experiencing as a result of weaning off. In fact, they want to use it against her. As of today, she's on no benzodiazepines. And in fact, the medications that she's on were not only approved by her psychiatrist, Dr. Capitaine, but their own psychiatrist, Dr. Miller, said that those medications were appropriate. What also the department, the Elitem, and the intervener haven't made sense, the 12-step program, asking her to recall the 12 steps. And she said, she told them what steps she was on. She provided a contact to Bobby Garza. Bobby Garza dismissed this and said, I did get a name. I did get a number. She never asked. She never followed up with the information that was provided to you. And in fact, court, Bobby Garza never did say, I called that number, and they said they didn't know Laura Melvin. Miss Garza knows she was afraid to call that number because they would tell you they knew who Laura Melvin was. Bobby Garza was also afraid to tell you the drug results of her hair follicle test because she knew it supported my client's contention that she was living a sober life. Judge, my client testified that she has several children. She has never been terminated ever. And this is the last child that she scientifically can ever have. She is in the fight of her life for the rest of her life, Judge. And my client has stepped up and is saying she is willing to do whatever this court asks her to do. As it relates to visitation with her children, she is asking for weekly visits. As it relates to the supervisor, it doesn't make sense that Judy Dickey continue to provide service. Let's ask why. Judy Dickey admitted that most of the negative things that she had about Laura and Lexi's visits were related to things told to her by the foster mom, who has something to gain from those visits being stopped. Not only that, Judge, I specifically asked Judy Dickey, if visits were to continue, would you be willing to supervise these visits? She continued telling me she was not in support of visitations continuing. She would not answer the question. Why would we continue going down a yellow brick road of no hope when she has built a brick wall blocking my client's ability to reunify with the child? She has eliminated herself by providing information to this court that there is no future, and she's not willing to support that. We need someone that actually follows the guidelines and procedures of the Texas Department of Family and Protective Services, their own CPS handbook, which, by the way, Bobby Garza didn't even know herself, presuming positive tests for tests that presuming positive incorrectly tests. In this case, Judge, that the department's main goal is to make reasonable efforts for reunification. What we are asking is for the court to right a wrong and to reinstitute visits between Lexi and my client, and that a new supervisor be appointed, Judge, and that you give her a chance to reunify Lexi with her biological siblings, that not one person in this courtroom outside of Laura Melvin has taken the time for her to know her biological family. And with that, Judge, I rest.
All right, briefly, Ms. Merritt.
Judge, I'm sorry, before Ms. Merritt responds, I believe CASA also wanted to say something.
All right, CASA.
Yes, Your Honor. As a case supervisor, I do oversee the advocate to which you heard testify earlier today. So in my role, I personally have attempted to observe 6 different visits. And of the 6, 2 were in person and 4 were virtual. With only 2 of those times, Laura actually attended. Both of the visits that I personally attempted to observe, or all of the visits, I'm sorry, were not positive. December 28, 2019, it was a KidShare visit. KidShare ended up canceling this visit because Laura was incoherent during this visit. So that visit was canceled. Another visit that I attempted to observe was February 15, 2020. Laura never showed up for this visit. This was another KidShare visit. And Lexi was in the car waiting for her to show up for 20 minutes. Another visit that I attempted to observe was April 4th, 2020, which was a virtual. On this virtual visit, Lexi waited for 30 minutes, which Lauren never connected to this visit. Your Honor, this child is thriving in a capacity that she's never been allowed to before. As now she has a sense of consistency and stability, and reinstating visits with Laura Melvin would be detrimental to the well-being of Lexi. CASA feels it is not in the best interest of Lexi to reinstate these visits. Lastly, Your Honor, if you do feel that reinstating these visits is the appropriate thing to do, I would urge that Judy Dickey does continue to be the monitor of those visits, as she does have the rapport and the understanding of Lexi to provide that support and the most knowledgeable feedback to all the parties. Thank you, Your Honor.
Ms. Barrett?
Judge, I just want to say that throughout Ms. House's conclusion, at no point did she indicate best interest of the child, except for the time about the contact with her siblings. She consistently indicated that it was in her client's best interest to continue visits, that it was in her client's best interest to move forward in this case. She also said that the department is required to provide reasonable efforts. And I believe, Judge, that you have heard that reasonable efforts to work with Ms. Melvin have been made. Reasonable efforts do not mean extraordinary efforts. Reasonable efforts does not mean something that is not reasonable. And I believe that the department has provided reasonable services to Ms. Melvin to help her with her addiction, with her sobriety, and, with the final order of this court, which incorporates the mediated settlement agreement. And that mediated settlement agreement required her to attend these counseling sessions, psychiatric and psychological evaluations, and all orders of the court, not just the ones that she thought she believed were necessary, all orders of the court. Judge, I think that in the best interest of Lexi, that we need to look at what Lexi needs. And at this time, Judge, I think Lexi needs to let us go to trial and get another order in terms of the motion to modify and continue the status quo at this time. Thanks.
Ms. Pearsall, briefly.
Judge, I think Ms. Merritt has said it all, and you've heard it all. I trust this court to protect Lexi from being harmed.
Ms. Sims, anything?
Your Honor, I have nothing further. I would just ask you to rule about what's in Lexi's best interest.
I've listened to the evidence carefully. I have in the last week read the transcript, previous hearing also. At this time, I will not restart the visits. I will sign an order over the weekend and e-file it for the SCRAM monitor and a patch system. I understand the department's position about budgeting, but I also know that we've coming up on like 16 and a half hours of hearings in this case just for me. I don't know how much that's going to cost the department between the salaries of the employees and the fees for the attorneys, but I think that will dwarf any costs of ordering the SCRAM monitor and the drug patch. It will dwarf it several times over, and the cost of the jury trial will also be dwarfed. If things are installed and they're used, if the jury will have some empirical evidence about whether or not Ms. Melvin is clean and sober 24/7 for a period of some weeks prior to the trial. think it would make their job, I won't say anything more than that. All right, so I will get that signed and e-filed. I think that's all I need on the patches. I guess what we need to decide on the patches is who's going to supervise them. Are there people that, is the companies that put them on, or do you just order a box of them and slap them on yourself?
Judge, so Ms. House and I both called around to multiple, I guess, probation officers, offices that do it. We talked to the Bexar County and Beeville, and there was in Austin, I believe, Travis County, their offices in both, in all three places.
Corpus.
I'm sorry, Corpus, Austin, and San Antonio, correct?
Mhm.
Okay. We did learn from that the same places administer both. It is a lot less expensive in Bexar County for whatever reason than the other two counties. The way the scram monitor works is they put it on her ankle, with her ID, and then they just automatically like sends updates, I guess, to them. With the patch, they put it on, and she has to come back, and I think we got a little bit of different answers as to how frequently. I think Ms. House was told that it was 14 days. I was told it's every 10 to 14 days. But they will tell her to come in and they will remove it and they will put on another one. And they say that if she tampers with it, they will be able to see that. So they have to put it on and remove it. And if you look at my proposed order, what I said, because we weren't sure what the true date is between 10 and 14, is that she just ordered to show up on the date that they require her to show up. Did that answer your question?
Yes. Okay. Anything else this evening?
Thank you so much, Your Honor. Feel better.
Judge, is there, okay, because there have been delays in this case, and we know how the department works. Is there an order as to when this needs to happen? Because when we asked for this de novo hearing, we asked in December. This hearing wasn't had until May. I'm afraid that if you orders.
Okay, I think one of the things I asked was for y'all to check and see if it was that the companies would accept a court order with the judge's signature on it and not have to wait for the department to cut a check or give a purchase order or something.
The companies, my understanding is they'll accept it, but I'm sure they're going to want payment.
Or I mean, accept it in lieu of payment up front.
Your Honor, I can just say that if the court has that order, the court makes the order, it signs the order. I have to give that order to the department. So it will go to the conservatorship worker, supervisor, and up. I'm also going to be forwarding that order to my managing attorney, and he will forward that up as well.
So, Judge, I guess my request.
That tells me nothing about, is it going to be August before it's approved, or the check actually appears?
Judge, it's my understanding when you make an order to the department, they must follow it. So if you say within a week, they need to follow that.
Well, they can also order Ms. Melvin upfront the cost immediately, and department has, their procedure to reimburse her.
She doesn't have funds.
They have. Okay, so the answer is nobody checked to see if they will take just a letter. I would, or just a copy of the court's order. I will ask y'all to research that on Tuesday and just email the coordinator with whatever you find out.
Your Honor, if I may, in my experience in having the department order to provide services, things get backlogged. It's going to take quite a bit of time, and they can also have the opportunity to file an appeal.
Oh, I understand. And I'm certain that there's certain things I would order that, yeah, there would just be assistant AGs in here filing something. So,
if I can refresh your memory, Ms. House offered that her firm would front the expense if the order says that the department is to reimburse her. I believe that is a more surefire way to have the monitor put on immediately, and Ms. House can fight to collect the judgment.
Yeah, but I'm not fighting an appeal. If you're talking about that they're going to appeal it and I'm not going to get my money back, then you've changed the game.
Judge, to interrupt, Your Honor, I have 20 minutes to be at the high school for graduation.
Okay. All right, you're excused.
Thank you.
Okay, Judge, if I can offer a solution, I know I've done this in other cases. I've never done an interlock. But I've had other cases which may fix this issue. If Miss House is ordered to, this her consent, to front the money for the interlock and the patch, you can order, Karnes County to reimburse it to Miss House. And then she includes it in her voucher and it gets automatically reimbursed to her. And as you order, Karnes County has to honor that. It doesn't involve the department. It doesn't involve any delay. It's just a court expense like we would get for, I don't know, service of process or, you know, an investigator.
Let's do it that way. I'll ask y'all to.
I mean, and so the court is ordering me to front the costs and then the reimbursement for the voucher.
Okay,
like,
I'm the person who approves the voucher. I'm
Okay.
the person who signs off on the voucher. So I would expect that I would approve that and order Karnes County to pay it.
Thank you, Honor.
Judge, I've never been ordered in this. I don't feel comfortable with a court order in this way. I want to be guaranteed.
Okay, okay, then we won't do it that way. I'll sign the order and we'll let it go to the department and let that happen, however that happens. If the company will take just the signed order and wait for reimbursement, great. If they want, then whatever happens, happens. All right, so anything else?
Thank you, Honor.